on the live stream.
And we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Fellow justices, staff of the appeals court, counsel in this morning's cases, and other guests, both on this Zoom video conference and also those of you watching the live stream on our YouTube channel. I especially want to welcome Justice Serge George from the Supreme Judicial Court and Governor's Counselors Mary Hurley and Marilyn Petito Devani, as well as many of Justice Walsh's former colleagues from the District Court, and of course, the members of her family who join in observing these proceedings. It is our great pleasure this morning to welcome the newest member of the Appeals Court, Associate Justice Maureen Walsh, who was sworn in on May 17th following her unanimous confirmation by the Governor's Council. Joining me on the virtual bench today, in addition to Justice Walsh, are Justices Ariane Vuono, Justice Suk-Young Shin, and Justice Joseph Ditkoff. By tradition, the Appeals Court employs an expanded panel of 5 judges for the first case heard by a newly appointed member of the court. For the remaining cases on today's hearing list, the 3-judge panel will sit consisting of Justices Shin, Ditkoff, and Walsh. Though our expanded panel follows appeals court tradition, even the most casual glance indicates that today's ceremony is not bathed in tradition. This is, in fact, only the second virtual induction ceremony in the nearly 50-year history of the appeals court, the first being the induction last October of Justice Marguerite Grant. Our ability to conduct such a proceeding, and for that matter, to conduct our regular oral arguments, despite the challenges of the global pandemic over these past 15 months, is the product of a great deal of very hard and effective work by teams led by our clerk, Joe Stanton, and our Deputy CIO, Jeff Travers, at the onset of the pandemic. Their work has made it possible for all judges, litigants, and staff of the appeals court to continue full operations without exposing themselves or their families to risk of contagion, and for that we are forever grateful. Justice Maureen Walsh graduated from the University of Massachusetts and the Western New England University School of Law. She began her career as a law clerk for U.S. District Judge Michael A. Ponzer in 1991. She then went on to become an assistant district attorney for the Northwestern District Attorney's Office from 1994 through 1998. She was appointed to the parole board in 1998, eventually serving as its chair until she was appointed as an associate justice of the Eastern Hampshire District Court in 2008 by then Governor Deval Patrick. Justice Walsh has served as the presiding judge of Holyoke District Court and most recently served as the presiding judge of Northampton District Court, as well as the regional administrative judge for Region 6 of the District Court, which encompasses all 4 Western Massachusetts counties. Of particular significance is her service as presiding justice of the EACH program, the Emerging Adult Court of Hope for persons 18 to 24 years old in the Springfield District Court. I would be remiss if I did not also acknowledge Justice Walsh's personal background as one of 8 children. I know from my own experience how that setting teaches one to get along with others in sometimes difficult circumstances. Though in Justice Walsh's case, as the youngest, she acquired greater kindness and patience in the process than if she had been the oldest. Here at the appeals court, we follow the custom used in the Superior Court of numbering our judicial seats in the order they were created. Justice Walsh is the 5th person to occupy seat number 10, created as part of the court's first expansion in 1979 and most recently held by Justice Edward J. McDonough Jr. The first occupant of that seat was the legendary Rudolph Cass. I would ask all of you to join me in wishing him and his family your best wishes and hopes during this very difficult period for his health. Other occupants of this seat include Justice John Mason and Justice Andrew Granger. I should also note that, counting all statutory and recall justices, Justice Walsh is the 76th person to serve as a justice in this court. It is an honor and a privilege to welcome Justice Maureen E. Walsh to the Massachusetts Appeals Court, and I invite you all now to rise with me to welcome our new colleague. Now that was less loud on the applause because everyone else was muted, but you get the idea. I will now ask our clerk, Joseph Stanton, to read Justice Walsh's judicial commission.
To all to whom these presents shall come, greeting. Know ye that we, by our governor, with the advice and consent of our council, confiding in the ability, discretion, and integrity of Maureen E. Walsh of Deerfield, do hereby, under the provisions of Chapter 211A of the General Laws, as most recently amended, and in conformity with our Constitution, constitute and appoint her to be one of the Associate Justices of the Appeals Court, to hold said trust during her good behavior therein, unless removed therefrom in the manner provided by our Constitution. And we do authorize and enjoin her, the said Maureen E. Walsh, to execute and perform all the duties, and she is invested with all the powers and responsibilities which, by our Constitution and laws, do or may pertain to the said office, so long as she shall hold the same by virtue of these presents. Witness His Excellency Charles D. Baker, our governor, and our great seal hereunto affixed at Boston this 17th day of May, in the year of our Lord 2021, and of the independence of the United States 245.
Thank you, Clerk Stanton. That concludes these ceremonial proceedings. Welcome, Justice Walsh. We will take a brief pause in the proceedings while we bid farewell to the non-sitting members of the court, and we will invite in the counsel for the first case.
And we are back live and on the record.
The first case on our list for hearing this morning is case number 2019 P 1832, the Commonwealth versus Shaun O. Harrison. As indicated at the beginning of the just concluded induction ceremony, this case will be heard by an expanded panel by tradition of the appeals court for the first sitting of our new colleague. Following the conclusion of the argument in this case, we will take a brief recess to admit this counsel for the second case, and we'll continue the hearing list with a traditional three-judge panel consisting of Justice Shin, Justice Ditkoff, and Justice Walsh. Okay, with that beginning, Attorney DeMaio, you may begin your presentation.
Thank you, Your Honor. May it please the court. Christopher DeMaio for Shaun Harrison. So there are a lot of issues. I'm not going to be able to deal with all of them one by one. I'm hoping to deal with what we take to be trial errors and evidentiary errors in sort of in the aggregate. And the gist of our argument is there was a lot of them. There was too many, and we concede a defendant doesn't get a perfect trial, and we concede here that the victim in this case pointed his finger at Mr. Harrison as the culprit, and there was some. The prosecution had access to text messages from Mr. Harrison's phone, so it was a strong case in that regard. Nonetheless, at a certain point, you begin to bump up against due process issues and just issues of what one should expect of a trial of a major felony where someone's going away for 25 years. It was not, and it's not a case without its own loose ends. Some of that was of the Commonwealth's own doing, I'd submit. They put on 3 former students, Perez, Arias, and Nova, who some of their testimony, it was contradictory. Some of it was just frankly incredible. One of them testified for the first time on the stand that Mr. Harrison had asked him to shoot the victim in this case. And then there are these 4 guys who were sort of at the periphery of the case. Wilson Peguero, Dante Lara, Oscar Pena, and Matthew Palacios. 3 of these 4 guys are seen coming out of 18 Pompeii, where Mr. Harrison lives, the day after the shooting with an unidentified woman. They're stopped, they have guns, they have drugs. They're clearly there more than that because Peguero's GPS anklet said he was there on the night of the shooting. Mr. Harrison's apartment, his living quarters, have they certainly had marijuana and scales. They certainly had evidence for a good drug case.
Mr. DeMaio, as you mentioned, you have an awful lot of issues to cover. We're familiar with the factual background of the overall case, and I think if I might just encourage you to dive into.
Okay. In any event, so my point is, it was a strong case, but perhaps not such an open and shut case as the Commonwealth would state, and that has to be weighed against It's a late disclosed interview video, and I'd suggest that's a major issue. It's the 5th day of a jury trial of a major felony. You get a 3-hour long interview video of a witness who's already testified. I'd submit it's not just that it has a coercive testimony or arguably coercive tactics. It's just chock full of names and interesting things that any competent defense attorney would follow up on if he had gotten it a month or two earlier when he should have. Including that the victim is in a gang. Now, this guy Perez is not the most credible person, so maybe there's not a lot to this, but you don't know until you look into it. And as Attorney Carroll said, you can't give me enough time during the trial to prepare for trial, and he was very clear about that.
Attorney DeMeo, but I didn't see in the record anywhere where defense counsel raised the issue of the possibility of discovering new evidence to the judge when he asked for the mistrial. Right.
Well,
I mean, I thought his argument was that he didn't have time to get an expert, and he might have cross-examined Nova differently, but I didn't see where he raised the issue of the gang membership or the other students that are mentioned in the video.
I don't know that he mentioned gang membership. I believe he mentioned Tyrese as someone who had testified before differently at the grand jury, and there's some other students in that same discussion with Tyrese. This is abuse of discretion. It's a tough standard, but I'd submit that when you look at the record, you just don't see a exercise of reasoned discretion here. On the days 5 and 6, when this first comes up, Judge Muse is saying this, what am I going to do? I could do this, I could do that. I'm not sure striking the testimony is enough. And then you get to day 8, and he's well, I kept the witness in the state, and I had it transcribed for you. And what more do you want? When Attorney Carroll was complaining that he wasn't going to be able to examine Diaz effectively on day 8. So that's one issue.
Let me ask you this question, if I may. One of the things that was offered to defense counsel here was the possibility of a continuance, right? That was one of the options that was offered during the course of trial. Why would that have been? I understand why trial counsel chose not to take that option, yeah. But why would that have been helpful to him? Why couldn't the issue have been cured if he had had some time to review the interview more in a calmer fashion?
Well, first of all, I'm not entirely sure that I agree it was off. It was thrown out there. A lot of options were thrown out, but it seems to me that would only be helpful for cross-exam. If he was going to recall the witness, that might be helpful. You might need a day or two, but he's saying I need to do other stuff. I need to find a witness or expert witness. I need to at least Tyrese and some of these other people, I need to track them down. I guess it depends how long. If the judge was going to give a 2-month continuance, maybe that would have worked. But I took it he was offering a day or 2, and I don't even know that it was an offer. So I think the judge was just musing about I could do various things. So that we'd say that was pretty serious. I briefly just touching on some other things. The movie of the victim moaning and groaning in the hospital is that was inadmissible unless this court adopts the Commonwealth's theory of 801D, and they don't cite any law for that, and I haven't seen any case. I read a lot of federal cases on Federal Rule 801D, and this is not an identification. I'm pretty the court will be making new law if it says it is in these circumstances, and it would be bad law, I'd suggest, because that's not really what the rule is about. The rule is about preserving testimony of an eyewitness when it was fresh in their memory, particularly when they later recant or don't are intimidated or whatnot.
What about the Adams case? I thought that said that if someone personally knew a perpetrator and identified them, that it fell under that rule.
I'm not remembering the Adams. Which case is that? It's the SJC case. I don't recall that. I haven't found any case. I don't recall that in Adams they wasn't actually using one of their senses of perception to identify the person, which is really the issue here that you just said it. It's got to be him because I figured it out using my powers of deduction. Therefore, that's identification. I've never seen a case. I don't think Adams says that. And there's just I won't go into further details. There's a lot of issues. I think the prior false allegation about dealing drugs at the school was also pretty harmful on the facts of this case, and I don't see how it had probative value except as propensity evidence in this case. When you put them all together, I would submit that strong though the Commonwealth's case was in some respects, it was not, like I said, a open and shut case. Skilled defense attorney could, there were some gaps where skilled defense attorneys could perhaps get a toehold, and there were a lot of errors here. And I would submit just the late disclosed on the 5th day of a jury trial video is in itself sufficient. But if the court disagrees with me on that, I want to talk about the sentencing a little bit. And there's 2 prongs to the sentencing argument. The first is that Judge Muse just didn't understand his authority and his discretion under 18B. And the second is that he said some inappropriate things at sentencing, which suggested that he was considering inappropriate things when he sentenced. And on the first prong, I just don't think there's any question that he misunderstood his authority under 18B. He didn't have the benefit of the Darrell Thomas case, but he said right on the record, it's a 5-year mandatory minimum. It's not. We now have the benefit of the Darrell Thomas case. So the question is what to do about it. And I would submit it should go back for resentencing. Now the Commonwealth says—
Was that raised to Judge Muse at the time of sentencing or at any subsequent time? I mean, there is a mechanism to bring a claimed error of law to the attention of the sentencing judge, and it's not clear to me that the defendant availed himself of that vehicle before bringing the question to us.
Well, it wasn't clear at the time, and he didn't raise it. No, he didn't raise it. But
when you say it wasn't clear, I mean you're pointing to statements that he made on the record at the time of sentencing. What's not clear about it?
It was not clear that he was incorrect at the time, is what I'm saying. He didn't have the benefit of the Darrell Thomas case, but the Darrell Thomas case came down while this case was pending on appeal, therefore it applies. Now, the Commonwealth says it doesn't matter because Judge Muse wanted to give Mr. Harrison a hard sentence and throw the book at him, and that's probably true. He did want to give him a hard sentence, but the question here is what would he have done, and we really don't know. If he had appreciated, I don't have to give him 5 to 6 years. I don't have to give a 5-year mandatory minimum. I could give 2 to 5 years. I could give 3 to 6 years. We don't know without speculating what he would have done. And I would also submit that perhaps dwelling too much on Judge Muse's subjective feelings is maybe not the right way to do this. And I had forgotten until I was preparing for this argument, there was a sentence appeal. It's on page 44 of the appendix. That it went to the appellate division has plenary authority. So, I mean, even if Judge Muse wasn't moved by the Darrell Thomas case, perhaps some other judge on the appellate division would have been. So it should be an objective standard, I would submit. What would an objectively reasonable judge want to know the correct parameters for the sentence when he's sentencing? Of course he would, even if we can speculate that maybe Judge Muse might not have in this case, but we just don't know what Judge Muse would have done. And this isn't like a Lattimore case. This isn't like where there's a strong presumption we're going to keep the status quo. It's the opposite. I cite Mills, I cite Suarez. There's a bunch of cases that say if you're in doubt, or even if it looks peculiar to from the outside as to how the sentencing went, the remedy is to remand for resentencing. So that's what we submit should happen here. And I have a totally independent argument that has nothing to do with 18B, which is that when the judge was sentencing Mr. Harrison, at least on so there's the big 18 to 20 years on the lead sentence of assault to murder. All the gun charges were put on and after, and he said that was because, I'll just read briefly, Lewis is a victim in this case, but in a larger metaphorical sense, the community is a victim. And then he goes on to talk about last year, the Superior Court reached another sign of the times benchmark across the hall. Down that hallway in courtroom 817, the courtroom became a dedicated gun session and so forth. And then there's talk about guns pouring across the border. And it's not an editorial, it's a lament, and it will bear on the sentence. And then more talk about courtroom 817, and then some talk about the homicide memorial. I'd submit that's just inappropriate. And the Commonwealth says this is general deterrence. It's not general deterrence. It's specific to Boston, specific to Suffolk County. It's courtroom 817. I mean, he's talking about Suffolk County. He's talking about the community. We cite the Hamilton case, which is an old case, not real old, but it's from the late 90s in this court. It says you can't send a message to the community. Still good law. It's been cited by the SJC recently. The Commonwealth doesn't even address it in their brief. And
How broad do you think general deterrence has to be to count as general deterrence?
General deter. I mean, all crime and all punishment is generally deterrent, I guess. So it's hard for me to know. I don't really understand general deterrence as a factor for a particular person. It seems kind of weird to me to say, like, well, the crime rate is up this year, so I'm going to increase sentence by a year. But in any event, it has to be Massachusetts wide, I would submit, if nothing else. And there's no question for what I just read. He's talking about the community. He's talking about Roxbury. He's talking about his courtroom and the gun session. And it's really pretty close. That we filed a 16L letter the other day, which was talking about something kind of similar. It was a judge who didn't like drugs as opposed to guns, but it was a similar situation. I think the panel there rightly said, no, this doesn't look right, and they sent it back down before another judge. And then, so aside from it wasn't general deterrence, there's just this sort of untoward appearance of a judge penalizing somebody, especially because he doesn't like that crime in particular that you have here. And that again kind of goes to the 16L letter that we sent the other day. And so for all those reasons, independently or in combination, we would submit that the case should be sent back down for resentencing. Judge Muse is retired, so it would have to go before another judge, at least on that portion of it. Those are the main arguments. I mean, I could talk all day about this case, but those are the main arguments I wanted to get to.
Well, Mr. DeMeo, I have to say, I did not expect you to make it all the way through your list of issues, but with the cooperation of my colleagues on the panel, you managed to do so, and I thank you for that. For the Commonwealth, you're going to need to unmute yourself, Attorney Campbell.
Thank you, Chief Justice. May it please the court, Julian Campbell on behalf of the Commonwealth. I'm here today asking that this court affirm the defendant's convictions that arise from his actions on March 3rd, 2015, when he brazenly shot one of his own students from a Boston Public High School in the back of the head.
Let's not focus as much on the crime as the issues that we have to deal with in this appeal, because whatever his the underlying crime may have been, he's entitled to a fair trial.
Absolutely, but what I think is important when this court evaluates all of the defendant's claims is the overwhelming strength, which I know my brother mentioned, but beyond the points he acknowledged, the evidence against the defendant, and I think this is important to the mistrial component, which is why I'm addressing it. But the most compelling case against the defendant included the video evidence of the shooting, the victim's consistent testimony, the defendant's own statements, his own phone and text messages, and beyond that, a glove and jacket were recovered from his home that resembled the glove and jacket worn by the shooter. And those gloves and jacket did have gunshot residue on them. And with that, I turn to the mistrial issue because I think it is important to stress that the import of Kevin Perez's testimony was as it related to motive evidence. And while that was certainly relevant, what the Commonwealth was able to rely on to prove the elements of the charges against the defendant were much of that evidence that I just recited to this court. And so while I acknowledge that the video was disclosed in the middle of trial, and which should not happen, and I do not excuse, this court has to evaluate what the consequences of that delayed disclosure would have been.
How can we sanction that as being permissible? The video, I think you would agree, was loaded with material that would, in the hands of experienced defense counsel, furnished a good deal of opportunity to, at least as to all of the other juvenile witnesses, to cast some doubt on their motive, their veracity, their actions in concert with the defendant.
And I acknowledge that there is discussion within that video regarding other students. I would suggest that much of that evidence was in the hands of the defendant. For example, the mention of Tyrese, I believe he had testified at grand jury. So I would suggest that much of the information regarding other students was known to the defendant.
But the nature of their testimony, the nature of their assertions also could, again, in the hands of experienced defense counsel, be suggested as the product of coercive activities by the police, who these children would have had reason to be concerned about, right?
Certainly.
And it was that latter prong that was, it seemed to me, in reading through the early exchange, the centerpiece of defense counsel's request for a continuance of more than a couple of days. He needed to engage, he wanted to apply for funds to get an expert and to be able to mount an entirely different defense strategy, attacking the reliability of the testimony of all of the juveniles.
And what I would suggest to the court is that in evaluating whether or not the defense would have been able to prepare and present its case in a manner as to create a reasonable doubt that would have not otherwise existed, all of those other students do not detract from the evidence that I recited to this court that established it was the defendant who shot the victim here.
Well, the fact that the Commonwealth was likely to get it would have been likely to get a conviction at the retrial means that no matter what they do, it doesn't matter.
That's not what I'm suggesting.
Well, this is very, first of all, I mean, I understand that there was no suggestion that the district attorney's office was aware of the interview, although, you know, both defense counsel and the prosecution had the report that included a reference to it. I suppose a more careful review would have revealed it earlier, but that it certainly doesn't seem to be purposeful. Whether it was purposeful in the hands of the police department is a different question.
I would suggest yes, but that there is no indication on the record that it was an intentional withholding. There's simply nothing in the record to suggest that.
I understand that because there was never an opportunity to explore that, but if we were to sanction this, to say that because the case was strong, the withholding of this kind of evidence is okay. What are we saying?
That's not what I'm asking this court to do. What I'm asking this court to do, Your Honor, is to decide whether or not Judge Muse abused his discretion when he offered a variety of remedies to the defendant, including not only recalling Perez, but the detectives who interviewed him were put on the stand after Mr. Perez was. Mr. Perez's testimony was offered to be struck. The defendant was offered a continuance, did not request any time, and I understand the position defense counsel was in, and I'm not asking this court to sanction the inadvertent late disclosure. That's not what I'm asking. What I'm asking this court to do is to determine whether Judge Muse abused his discretion in considering a variety of reasonable alternatives and considering and concluding that it was not a manifest necessity that a mistrial be declared. That's what I'm asking this court for.
Counsel, I noticed that court didn't wind up happening on the Friday before Memorial Day, giving defense counsel 4 days. Was that pre-planned or was that something that was a remedy here?
I believe it had been pre-planned, but I would suggest that the transcript reveals the court had indicated he asked defense counsel. I don't think there was a time limit imposed on what a continuance necessarily would have been. Is all I'm trying to get at.
No, but as a practical matter, there were certainly rather significant outside parameters on what would be realistic, right? You had 12 in the box, and any continuance would not go on for more than a couple of days at the outside.
Well, if there were 4 days already, I'd suggest an additional couple of days could have at least given defense counsel an opportunity to look into, and if after looking into what he had hoped to investigate, at least on a cursory look, there could have certainly been another point to revisit Judge Muse's ruling and say, Judge, this simply isn't enough. I've tried. It's not enough time.
Isn't that what defense counsel said when they resumed on after the Memorial Day weekend?
Defense counsel's position from even before that Memorial Day weekend was that there would never be enough time. Unless there are further questions on the mistrial issue, I'm happy to turn to the evidentiary issues, and I'd be happy to turn to whatever questions this court, if there's anyone in particular that this court has questions about, I'd be happy to go in that order. Otherwise, I can just go through.
I think it'd be helpful to talk about the sentencing. What do we do about the fact that defendant actually asked for a consecutive sentence, but the prosecutor asked for a 5 to 5 in a day, but the prosecutor asked for 4.5 to 5 in a day. The judge says he thinks it's got to be 5, but Thomas hasn't come out yet. So how does that affect how we review it? I mean, if there have been objections or Thomas had been before that, it would be obvious, but it's kind of complicated here.
So Justice Ditkoff, I think you just mentioned though that less than 5 years had been asked on that count. And I think Judge Muse's position was that the egregious nature of the defendant's crimes here warranted even his mistaken belief that a 5-year was a minimum. There was a request that he go below it, and he clearly exceeded it because of the seriousness of the defendant's crimes and the record before the judge. So in light of that, even with the judge not having the benefit of that case, I'd suggest that it was clear his intention was to give a 6-year sentence.
Counsel, I mean, that might be so, and of course we'll discuss that, but just assuming we don't buy that, how do we review the error when it wasn't preserved? On the other hand, the Thomas case hadn't come down yet.
Well, I think I'm struggling to answer that question because it wasn't raised below and because the judge didn't have the benefit of the case. And so I apologize to the court. I am struggling to answer that.
All right.
Unless there are further questions, I'd be happy to rest on my brief.
Seeing nothing but silence, I will infer that there are no further questions. I know that speaking at least for myself, I have lots and lots of questions, but I think we'll have to do our best with your briefs and with your very able advocacy on both sides.
And we are back live and on the record.
Good morning. We've reconstituted the panel. I remain Justice Shin, and with me are Justices Ditkoff and Justice Walsh. We will be your panel for the remaining 5 cases on the list today. So our next case is Commonwealth versus Kanani, number 20P247. Attorney Monroe.
Thank you. Good morning, members of the panel. May it please the court, Barbara Monroe for the defendant in this case, MURTADHA Kanani. Since the court is aware of the facts of this case, I'd like to focus on 3 key issues today. They're fairly simple and from my point of view. The judge's erroneous conclusions that plea counsel was not ineffective, that there was no prejudice, and the fact that this court can overturn the judge's decision and vacate Mr. Kanani's convictions without any need for remand. This court did a similar thing, as Judge Shin may be aware, in Commonwealth v. Mwangi, Kevin Mwangi, where very similar facts, and the court did find no need for a remand and also found that counsel's advice was incorrect and that there was a substantial defense available. So there were 5 different arguments that Mr. Kanani made claiming that counsel was ineffective. The judge really only addressed 1, and the Commonwealth now concedes to 1 of them, possibly 2, but any of the 5 that we addressed here are sufficient to satisfy the performance prong. First one that the Commonwealth does concede to, they concede that if, as it is said in the day of plea affidavit that Mr. Kanani signed, that if trial counsel told him he should contact an immigration attorney on his own prior to entering any plea, that would be an effective assistance of counsel. And the judge did credit, although he didn't say explicitly that he credited the affidavit of Mr. Kanani that was written on the day of plea, he referred to it in his finding extensively. So that implicitly.
Counselor, I thought your client in his affidavit said that didn't happen until after the plea.
He said it happened after the plea. It is disputed whether it happened before or after. I think that it makes no difference whether it happened before or after.
Well, why does what happened after the plea make a difference to whether the pre-plea advice was effective?
Well, if it was truly made after the plea, it doesn't make any sense, because what he said was he talked about admissions, but it was really a guilty plea. So it's very unclear when it was written, but it was written by trial counsel. And as I say, it doesn't matter when it was written, before or after. It's disputed, but I don't think it matters at the end of the day. Quite frankly, what I think counsel should have been doing, instead of writing an affidavit, as he says, quote unquote, to cover his own ass, was to call Immigration Impact Unit himself to find out what the consequences would be. He himself recommended three aggravated.
What do you think the PAC unit would have said under these circumstances?
What they would have said was, they would have said that the plea as it stands now that trial counsel recommended are pleas to aggravated felonies, which means more than he's out of here. It means there is no relief possible. He is going back to a place, a country that he was more likely than not to be tortured or killed to.
Counselor, wouldn't that be ineffective advice? Because we know that's not true. It is not the case that pleading to this will definitely mean that he gets deported to Iraq, because he's got a CAT claim. That's a meritorious one.
I'm sorry, could you repeat that? I didn't hear you.
He's got a meritorious Convention Against Torture claim. It's certainly not clear that he's going to be deported to Iraq. So if he was told, you'll definitely be deported to Iraq, reject this one-year probation deal, go to trial and maybe get time, I mean, that's ineffective, right?
Yes, if he tells him, wait, I'm sorry, run that by me again.
Wouldn't it be ineffective to tell him he would definitely be deported if he pleads to this? Isn't that
Not necessarily, because at the time of the plea, he did not have any CAT application pending. So you have to look at it at the time of the plea, which is what one of the errors that the Commonwealth makes, is they talk about how Judge Locanto could have taken into consideration that he'd been granted CAT, but he can't, because you have to look at it at the time of the plea.
But didn't he have a CAT claim at the time of the plea, and thus it was not good advice to tell him he would definitely be deported?
He did not have a CAT claim at the time of the plea.
He had a claim he could make under the Convention Against Torture, whether or not he did yet, that he could raise in enough time to prevent himself from being deported. I mean, we know this because that's what happened.
Correct, after the fact, but at the time of the plea, he was not aware of anything such as CAT. He had no idea that even existed, but more importantly, he was not aware that telling somebody, if he did, that he's out of here means he is going back to Iraq. He's never going to have a chance to come back here. Clearly, Mr. Kanani was concerned about that, because when he heard the judge say that in the hearing, in the plea colloquy, he stopped him and he said, yes, I do have a question. Does this mean I'm going?
No, the CAT claim might not be relevant to the prejudice analysis, but surely it's relevant to the first prong, is it not? I mean, if the plea counsel, it seems at least from the transcript of the plea hearing, that counsel advised him that a likely consequence of pleading guilty would be deportation. Isn't that actually accurate advice, given what happened with the CAT claim?
No, because the CAT claim was not even on the table at that point. Nobody was aware of any CAT claim, and you can't say it's likely. He was a possession with intent to distribute means you are going to get deported. It's
well, it doesn't mean that, because he's not getting deported. I mean, you can't say that. It doesn't mean you're going to get deported when you are Kanani, because it doesn't get him deported.
At this point in time, it doesn't, but you can't focus on this point in time. You have to go back to the day of the plea. And at the day of the plea, first of all, counsel wasn't even aware that he was a refugee. So he wouldn't even know that that was available to him.
He might have gotten the right advice by accident, but we still have to determine whether the advice was correct.
Attorney Monroe, let me jump in for a moment. And as soon as the plea occurred, your client says, does this mean I'm getting deported?
Yes.
Do we know the conversation between counsel and Mr. Kanani at that time
When he asked that question,
to Judge Locanto?
when he asked that question to Judge Locanto simply repeated
Right.
his 29 Ds.
And was there a conversation between trial counsel and Mr. Kanani about what that means?
According to Mr. Al-Kanani, there was, and when you listen to the tape, you could hear trial counsel talking to him. You couldn't hear what he said. According to Mr. Al-Kanani, without even hearing the tape, he said that he told him the judge has to say that to everybody, it's okay. I mean, the trial counsel told Mr. Al-Kanani and the judge at the hearing that this means he very likely could have immigration consequences. That is not the standard when you're talking about possession with intent to distribute.
Isn't that true if you have a valid Convention Against Torture claim?
But he didn't.
But he did. I mean, he did. I mean, you can't, he did, because he did it and he got it.
But you can't take that into consideration because trial counsel didn't say to him, okay, but you might not get deported because you have a valid Convention Against Torture.
Let's say he had said that to him. Would that be then adequate advice?
If he had said that, possibly it would be, but he didn't say
Okay.
that.
So is it ineffective for a defense attorney not to research the Convention Against Torture to ascertain whether his client has a viable claim?
I would say yes, but also I would say he wasn't even aware that he was a refugee. So how could he even research that?
So Attorney Monroe, is your argument that whether Mr. Kanani was charged with a shoplifting third offense or another non-deportable, that it would be ineffective assistance of counsel for a generic statement by an attorney advising their client that this is very likely that you'll be deported?
Yes.
Because that's what the nub of your argument is that he didn't know he was a refugee. He didn't, at some point in time, there may have been some conversation of whether he was in the cell or after the cell saying, you should contact an immigration attorney. And if there was no other evidence but, hey, the judge has to say this, that the blanket statement of, hey, whatever you do, you likely may face deportation isn't good enough because it's just blanket protection.
Correct.
That didn't apply because he didn't even know enough about his client. Do we know how long he actually counseled his client before the plea? Because this is a probation violation. The guy's in custody, right? And this is a conversation while there's guards around, while there's cell, and the judge is waiting to determine whether he's going to do a violation hearing and lock him up or whether there's going to be a global resolution. I mean, do we know the length of time? Not that length always matters, but
No, we don't know the length of time. But what I would say is that based on what he even told the judge at the hearing, he said, I told him that there could likely be significant immigration consequences. When you're telling your client what the consequences are, you have to be specific as to that client, their circumstances, and each specific charge. He recommended 3 pleas to aggravated felonies. It was a disparate plea. He could have said, hey, what about straight possession? Then he would have had cancellation of removal as an option for relief, but he didn't. He told him himself, you call an immigration attorney. Lavrenenko is very clear. You cannot tell your client that. Otherwise, there's no point in having counsel. So he and the Commonwealth concedes this point. If that's what he said, then he was truly ineffective. So from the baseline, if you don't know what your client's status is, how can you actually tell him?
Could I go back to advocate? Yeah, no, I'm sorry, Justice Shin, go ahead. Could I go back to a question that Justice Ditkoff asked? Let's say there was a very favorable offer on the table and counsel advised the defendant the way you're saying he should have now, which is you will definitely be deported. So then he chooses, I to go to trial, which I think would be a reasonable possibility, and he's convicted, and then he gets the deferral of removal. Wouldn't you be arguing that that advice was deficient?
No, because it's at the time of the plea. You can't focus what happens after the plea. So you can't say, well,
it was inaccurate advice to say you will definitely be deported.
no, it was, no, because it's a possession with intent to distribute. That's an aggravated felony. And there's a very narrow window of relief available for that. And Convention Against Torture is one. But the other problem with that too is it's only a deferral. So that doesn't mean that he's never going to get deported. That could change at any time, or they could deport him to a different country. So it's not accurate, and you can't take into consideration if he had been granted Convention Against Torture at the time of the plea. I don't even know how that would play into it, but the bottom line,
Attorney Monroe, that really goes to prejudice, though, really. I mean, that's the showing of prejudice, that just because he has that protection doesn't mean that he won't be deported to another country, correct? I mean, I think what your claim is, if I understand you right, is that because he didn't know he was a refugee, because he didn't know the consequences of the reality of the plea, he never even tried to negotiate with the Commonwealth, or there's no evidence to say, instead of the guilty, which I'm recommending, I need to get another charge so that there's less of a possibility of deportation. And he didn't do that.
correct, he didn't. And even Judge Lecanto agreed when I talked to him at the motion hearing that when counsel asked after the fact, he tried to get a sentence changed to 364 days probation. That is very clear that he doesn't know what that means, because that has no bearing on, the sentence has no bearing when it comes to drug cases. But he could have asked for a straight possession. It was a disparate plea. There would have been no harm in asking for that plea. And Mr. Kanani, had he known, because he was concerned, as he told the judge, is this going to result in my deportation? He would have gone to trial. And under Lee, any chance is better than none.
Well, Counselor, under prejudice, you skip the first step, which is first the defendant has to aver that he would have gone to trial. And the only thing, unless I'm missing something, your client says is, if I had known it would mean certain deportation and being sent back to Iraq, I never would have agreed to the plea. So considering that it's not certain deportation and certainly not certain deportation for Iraq, we even have the first prong of prejudice under Clark.
No, I would disagree respectfully that you can't take the cat into consideration. Mr. Kanani said in his affidavit that if he had known it was going to mean he was going to go back to a place where he's been tortured already, he would never have taken the plea and he would have gone to trial.
If we vacate it, what would you advise him to do?
If it came down to the bottom line, I would go to trial because there's nothing left to lose.
You could go to jail when you can't be deported now.
But you could go to jail, but your family is still here to visit. And Lee is very clear that for somebody in his shoes, and you have to look at it from his shoes, what would you do? And I would rather sit in jail where I could visit with my family than go back to that country where I'm going to get.
Your time's almost up, but let me ask you this. If we disagree that we have to completely ignore the fact that he has a triable Convention Against Torture claim at the time he does the plea, if you're wrong about that we can actually consider that, do you have a case? I mean, everything you've said is based on that he was definitely deported. If we disagree with that, what's your case?
I'm not understanding the question, I'm sorry.
Do you have a valid appeal here if we disagree with that, or is that where all your cards are?
A valid appeal or?
A successful appeal, meritorious appeal. What is your claim if we don't accept that?
If you don't accept that.
You have to ignore the Convention Against Torture.
Well, I would say that because he never told him the accurate advice that there was no relief available. The fact that he told him to call an immigration attorney. The courts have been clear that this is absolutely not his duty. It is trial counsel's. Failure to even learn of a refugee status to try to figure out what his possibilities are. And the fact that he himself recommended pleas to aggravated felonies, which for Mr. Kanani basically means certain death if he goes back to Iraq. I see my time has run out. I'll rest on my brief. Thank you.
Any further questions? Attorney Solois?
Good morning. May it please the court, Abigail Solois on behalf of the Commonwealth. Judge Locanto correctly determined that the defendant failed to prove that he suffered prejudice from plea counsel's purportedly inadequate performance. If I may, I'd like to start by talking about my first argument, which is that the defendant failed to establish with credible evidence that plea counsel was ineffective. And this argument sort of breaks down into three sections, one being the affidavits, the second being the judge's warning, and the third being plea counsel's statement regarding that the defendant would be out of here. Forgive the colloquialism, that's a transcript quote. But regarding the affidavits, the judge was not required to credit the defendant's self-serving affidavits. That's clear from all of the case law in this area. And notably, in this case, the defendant failed to provide an affidavit from the plea counsel about what he had in fact advised the defendant.
Isn't that unfair where the defense counsel asked for the affidavit and in fact gives us quite a bit of information about what defense counsel said, not all of which is helpful. I mean, so we know we're getting the true story here as to what they've been, well, we don't know, but we suspect we are. I mean, can you really count on not getting an affidavit when an affidavit wasn't provided, even though asked for?
It's certainly not the defendant's fault that we don't have an affidavit from plea counsel, but the fact is still true that we don't. And all we have is the defendant's word, which is obviously self-serving, and the other affidavits that we have. So we also have some from the defendant's legal team that was appointed after the immigration claim came to light. But of course, that's based on the defendant's self-reports of what happened. So I'm not blaming the defendant that we don't have it, but it's very different from the Arelis case, which my sister suggests that this case should come out the same way, but a stark difference between the two cases. We don't have plea counsel's affidavit where he says what he did in the case.
Counsel, shouldn't this have been an evidentiary hearing? Aren't there so many unanswered questions? We don't have the affidavit from the attorney. We don't know how long he spent speaking with his client. I mean, there's a lack of evidence. So
certainly, Your Honor, looking at the timeline here, we do know that plea counsel's representation of the defendant began in October of 2016, and the plea was entered in March of 2017. So there was quite a lot of time. Certainly conversations, I'm sure, took place between the defendant and his attorney during that.
I mean, probably
more than 1
not,
year of
because we know the practice of district court. It wasn't until he was in cuffs in the cell that the plea came up. And at that point, even if he had 6 months to talk with him, he didn't know that he was a refugee. Wouldn't that have affected had he known, the back and forth negotiations between the Commonwealth and his attorney?
Well, two different answers. First of all, I just want to make the point that I did in the Commonwealth's brief. I point out that the court is supposed to be looking at the defendant's circumstances that existed at the time of the plea. And the defendant, although he did come to the United States as a refugee, he had lawful permanent residency at the time of the plea. So that doesn't constitute a special circumstance in the defendant's particular case. And to your point regarding, I absolutely agree that there were a lot of facts that were not agreed upon nor apparent on the face of the record. But the defendant, as the moving party, looking at the Bernier case from 1971, the defendant has the burden of proving those facts that weren't agreed upon nor apparent on the face of the record. And the defendant hasn't established his affirmance with credible evidence in this case.
But if it appears he could, or at least plausibly could prove that if he had an evidentiary hearing, doesn't he get one? Doesn't have to prove it without an evidentiary hearing, does he? Just show that he's got a good shot at doing it at that. Is that right?
That's right.
I mean, so what about the out of here? I mean, the motion judge really relies on the out of here, but how can we know whether out of here meant out of this holding cell or out of this country without getting some evidence on what the context of that conversation was?
Absolutely, it would be, I would love it if we had context on that. What I have come up with on that particular point is looking at the record appendix, page 306. So that's it's a portion of the transcript. It's lines 9 through 18. And during that portion of the plea hearing, plea counsel indicates in somewhat of a detailed manner his explanation to the defendant of what would happen if he violated probation. And that belies the claim that out of here referred to, out of here meant you're going to jail or you're out of here if you violate. So it would have been repetitive for him to say that in two different portions of the transcript. So
let me interrupt for a moment. Would you agree with me that it would be ineffective assistance of counsel if an attorney, an experienced attorney in criminal law in probation violations, makes no inquiry as to refugee status, potential immigration results, but let's just say in every case makes a blanket statement of whether it's this defendant or any other defendant saying it's likely that you'll be deported if you're not a citizen.
Absolutely.
I'll tell you all about the probation violations, what will happen, because that's what I do. Hire your own immigration attorney. But if I just say the words you'll likely be deported, do you think that's ineffective assistance of counsel if that's the extent to which your advice is to your client on each and every case?
Respectfully, Your Honor, I don't think that was the extent of his advice in this particular case. He says on the record he knew that his client or the defendant was a green card holder. So he had inquired about his client's refugee status, immigration status. So he knew that he had a green card. So his status was not that he was a refugee. The defendant had come here as a refugee in 2009 and had obtained lawful permanent residency in 2011, which was retroactive to his date of entry. And
but we know it wasn't permanent residency, right, counsel?
Yes.
Right.
Just green card holder, we'll say, but yes, it's lawful permanent residency.
But we don't know. That's my point, is that we have no evidence whether this attorney blanketly just provides advice that this is likely to happen. Just with all due respect, what the judges do in their colloquy, whatever your situation is, but the attorney's responsibility is more than the judge's colloquy under Padilla, correct? It requires more, but yet
yes, it certainly requires more.
But we really don't know exactly, other than the out of here, and I knew that he came in with the green card. There's nothing more for us to.
There is nothing more. There certainly should have been more. I mean, he should have said these particular offenses, if you plead guilty, mandate your deportation. However, because of your history, you have a valid claim and you can apply for protection for deferred removal under the Convention Against Torture. So this, everything is specific to that particular defendant. And because of his history, he wasn't going to be definitely deported. He had a valid claim, as we see, because the immigration judge granted it.
Is that the standard we're imposing on defense attorneys, that in order to be constitutionally effective, he had to say, you will be deported except you have potentially a valid claim under the Convention Against Torture? I mean, is that the level of advice that's required of defense attorneys?
No, of course not. And to be totally frank with this court, I didn't know what the Convention Against Torture was until I got this case. So of course not. But to tell him you will absolutely be deported because of this guilty plea, that actually wouldn't have been complete, because had he, as we saw, this particular defendant has this added layer of protection, which means that his deportation is highly, highly unlikely. And looking at the standard of review that this court is asked to apply, it's whether or not Judge Locanto abused his discretion in denying this motion to vacate the conviction, right? So that's what we're looking at. And at that point in time, so looking at the timeline, the motion hearing took place November of 2018. The defendant was granted this deferral of removal under CAT in July of 2018. So the factors that Judge Lecanto was called to weigh that were relevant to this decision, the CAT designation was one of those factors, and a very important one, the Commonwealth would suggest. So
why is the result of the CAT process something to consider, as opposed to, at the time of the plea, the possibility of the CAT process?
Could you repeat your question, Justice?
So, I mean, you were talking about the judge can consider how the CAT process resulted, but isn't the proper question at the time of the plea, how likely was it that you would get CAT protection?
I think, I mean, they're two different questions, right? So the court was aware of this defendant's history. So all parties were aware of his history and that he was subjected to torture in his home country and that caused him to come here as a refugee. So that would, the facts that caused him to get deferred removal under CAT existed at the time of the plea. But
counsel, again, not to jump in again, that wasn't known at the time of the plea. At the time of the plea, trial counsel had no clue about the background of this defendant, other than green card holder, right?
He knew he was a green card holder, yes. Yes. But looking at, we're called to look at, even if the plea counsel was ineffective, the defendant wasn't prejudiced in this case. The defendant suggests that he had a strong case, so had he gone to trial, he may have succeeded at trial. But that simply isn't the case. The officers discovered a large sum of cash on the defendant, which the SJC has said that it's certainly probative of intent to distribute. And
hasn't the defendant made a very strong showing of special circumstances here? And that's enough to establish prejudice.
So,
I mean, no matter how weak his defense at trial would have been, if pleading guilty meant he would be returned to Iraq, I mean, isn't there a reasonable probability he would have gone to trial no matter what?
Looking at the special circumstances prong, so again, as I stated before, this case is distinguished from the Lavrenenko case because the defendant was not a refugee at the time of the plea. And also looking at the lease, forgive me if I'm pronouncing it wrong, LYS case from 2018, the judge was supposed to evaluate the factors that existed at the time of the plea. And in Lavrenenko, the SJC said that the presence of special circumstances alone might establish precedent, but the SJC does not agree that special circumstances alone establish prejudice. And that's a quote, I'm sorry, from Lavrenenko. And
wait, I'm not understanding that. Could you repeat that? Or what did the court find? Was the court saying that as a factual matter in that case, there weren't special circumstances?
No, in that case there was, because the defendant in Lavrenenko was a refugee at the time of the plea, different than this case.
But you said that the court said that alone wasn't enough to establish prejudice?
It said it might, but not necessarily.
As a matter of fact? Or
as a matter of law? As a matter of law, it said presence of special circumstances alone might establish prejudice. In that case it did, because the defendant was a refugee. But the SJC does not agree this.
Why wouldn't it here, considering the awful things that will almost certainly happen to this defendant if he gets sent back to Iraq?
Because again, I mean, moving the timeline forward to what Judge Lecanto was faced with at the motion trial, that's not going to happen to this defendant. And he's supposed to be, under Rule 30, he's looking at this to see whether justice was done, and that it's a very high bar for vacating this conviction. And he has to look at the factors relevant to the decision.
But in the Padilla analysis and on the prejudice prong, aren't we supposed to look at the circumstances that existed at the time of the plea, at least on the prejudice prong? Because isn't the question whether he would have chosen to plead guilty had he received adequate advice? And if that's the question, then how do we consider something that happened later?
I think it goes to, you have to look at the full picture, of course. And in this case, it's his claim that he would have chosen to go to trial, I don't think is very persuasive or credible in this case. I mean, look at the conversation that I'm fully aware that the judge's warning is not a substitute for proper advice of counsel, but if you look at the back and forth, in the Clark case, it says that the judge's warning is relevant to the prejudice prong. So there was a very thorough back and forth where Judge Lecanto said, do you want more time to talk to your lawyer? And he spelled it out. He said the magic words that is virtually certain, your deportation is virtually certain if you plead guilty to certain offenses. And now that you understand that, do you still want to plead? So that goes to his credibility. And I see that my time is expired.
Are there any further questions?
I've got one technical question. Your friend suggests that after the defendant said, will I be deported, that he consulted with counsel, and there's certainly a indiscernible on page 52 of the plea transcript. Do you either agree with that or at least don't disagree with that?
It's indiscernible, so there could have been a motion to reconstruct the record, but what we have in front of us, we don't have that information. And since that motion wasn't done, I would ask the panel not to consider that. It's a representation of counsel. It's not part of the record.
Okay.
Thank you, counsel. Thank you both. It's a very interesting case, and your arguments have been very helpful to us. And the case is submitted.
And we are back live and on the record.
I'm not used to that recorded voice yet. All right, the next case on our list is Commonwealth versus Sitcot, number 20P887. Attorney Pickett.
Good morning, Your Honors. Welcome to the court, Justice Walsh. I know Your Honors are familiar with the record, and it's not an extensive record. And frankly, the facts aren't in dispute. I don't dispute any of the judge's findings. I've read through the officers. There were 3 officers that testified that responded to the scene, and I've read through all their testimony. And so what we do know is that the motion judge, understandably, because Torres Pagan had not been decided yet, conflated the standard of an exit order with the standard for a pat frisk. We know under Torres Pagan that they're different, and that the standard for a pat frisk of a driver or a passenger is a heightened one. And essentially, under Torres Pagan, the Commonwealth has the burden of showing at the time of the pat frisk that Mr. Siccotte was presently armed and dangerous. I would suggest, Your Honors, that I would argue that there wasn't reasonable suspicion that he was armed, but there literally is nothing in the judge's findings or in the testimony of the officers to suggest that he was dangerous. As I was thinking about what does dangerous mean, I started to think, well, isn't this sort of subjective, and what does this mean? And then I realized the courts have defined what armed and dangerous mean, and that standard is set forth in Commonwealth versus Narcissi. And I'll read it to you. It says, it's a reasonable belief that an individual has a weapon and appears inclined to use it. That's both of those factors need to be present in order to justify the pat frisk that happened here. We know that the judge-
Why isn't the furtive gesture enough here?
Yes, so we know that the judge said that the furtive gestures were enough to justify the exit order, and then used those furtive gestures to say that that also was enough to satisfy the pat frisk. And as the Commonwealth points out, in Torres Pagan, the court itself said, well, in the past, we have said, one thing that was going on in Torres Pagan is that there were no furtive gestures. And so the court was doing sort of a compare and contrast and saying, well, in these cases, there were furtive gestures. But essentially, even in Torres Pagan, they said, this is one factor. There's many factors that go on when you look at the totality of the circumstances. And if you look at the cases, which I have cited in Torres Pagan, there were other things going on. There were reports of a crime, or in one case, the suspect produced a false identification. What we know here is that, as the judge found, the defendant was in the passenger seat in the back, and he was reaching back and forth between the pocket in the back and his midsection. Another officer said that he saw his hands saw the defendant's hands in sort of the pocket area of his sweatshirt. And that's all the testimony was. In fact, if you look at the officer's testimony, both of them say they were extremely close to the windows of the passenger seat. Officer, I think his name is Laganis, had a flashlight shining in on the defendant, and that's where he said he saw the defendant moving his hands back and forth. But he said specifically that he thought there may have been an item. There was no identification of what he thought that item was. None of the officers testified that they thought it was a weapon. And so I would argue, Your Honors, that there really wasn't enough under the safety standard to justify the exit order under the under that standard. But I have to concede that there was enough, obviously, because the driver didn't have a license and was being arrested on a warrant. The other two passengers didn't have a license. And so under the Lowell Police Department policy, the car was going to be towed. So obviously, Mr. SICOTTE and the other female passenger had to get out of the car. That's understandable, perfectly supportable under the Constitution. The issue is presently, at the time that the defendant exited the car, what was going on? Well, we know that the driver had been arrested. He was handcuffed. He was brought to another small parking lot. The girlfriend was with him. And we know at the time that Mr. SICOTTE exited the vehicle, at all times he had been compliant with the officer's orders. He had held up his hands as they asked, which maybe would be an appropriate response for the officers to do in light of the fact of the movements back and forth. So the officers had addressed any safety concerns. And what they found is that Mr. SICOTTE was completely compliant. He was compliant getting out of the car. And unlike other situations where there was a volatile scene going on, that wasn't the case here. I mean, the driver was arrested without incident. Interestingly, unlike some of the other cases, there was nothing to suggest that Mr. SICOTTE had any criminal involvement in anything. And interestingly, the police officers didn't say even the driver was arrested on a warrant for armed robbery or murder. For all we know, it could have been court fines, and he was arrested without incident. When you look at the timing, we know that the two passengers and drivers gave the officers their identification. The officer said it took probably 3 minutes to run it. Then we know that they took the driver came out of the car, they arrested him, they moved him away. The girlfriend got out of the car, she went over to him. It's hard to estimate how long this took, but during the whole course of this time, Mr. SICOTTE was under observance by the police officers. One thing I noticed today that was really interesting is the third officer, who didn't really have much to do with Mr. SICOTTE's part of the case. Officer Coyle testified that at the time that Mr. SICOTTE was taken out of the car, because at the time the driver was arrested, he said on page 81 of the motion transcript, "We had a couple of marked units there as well. And, quote unquote, we had ample help there." So not only was Mr. SICOTTE being observed by two officers at gunpoint, undercover officers, there were also marked backup there, ample backup, according to Detective Coyle. My point is that at the time Mr. SICOTTE exited the car, he hadn't done anything wrong. He was free to leave. So the officers can't at that point say, oh, we had to pat frisk him for what? He was a passenger in the car. He couldn't drive the car, but they never said they had any suspicion that he was engaged in criminal activity. I also want to point, Your Honors, and I'm sorry, this case came out, and I'm sorry, I call them 128s because I'm so old and I forget what the rule is now. Anyway, it's an unpublished decision of this court. And I know this court has been grappling with, well, how far does this extend, right? And it's complicated. It's hard to know what the boundaries are. I was just watching the SJC argument in the Sweeting-Bailey case, And you can tell that those justices are struggling with the boundary lines as well. And I understand that, because obviously there's a need to protect police officer safety. But at the same time, it can't come on the heels of an unreasonable, unconstitutional pat frisk, which, you know, the courts have always recognized is a significant intrusion, and, you know, sometimes humiliating intrusion. And it's something that requires, as in this case, a reasonable suspicion that Mr. Siccotte was armed and that he was inclined to use whatever weapon he was armed with. And I would suggest that there's zero evidence of that. The case I was talking about, which is Commonwealth versus Brockington, and I'll give you the case number here. It's 19-P-222. Essentially, in that case, the defendant was a passenger in the car. The car was being stopped because the police officers had been observing this house where they suspected drug activity, and there was a lot of comings and goings. It was very late at night. There was some kind of interaction there, that the car leaves from that place and it gets stopped. And in that case, the passenger was pulled out and pat frisked. And this court said, the motion judge placed the quote unquote greatest significance on the fact that the defendant moved her hands out of Sergeant Gaines' line of sight and toward her lap several times. In reaching his conclusion, the judge also relied on the late night hour, the defendant's unusual nervousness, and that she provided false information in response to Sergeant Gaines' questions. These considerations did not create a reasonable belief that the defendant was dangerous and that she possessed a weapon. Well, I would assert that in this case, if those circumstances don't suggest that the defendant was armed and dangerous, that certainly can't be met here, because there she made furtive movements and the officers couldn't even see what she was doing. And here we know that the defendant at all times was holding his hand up, complying with the officer's orders. And so I would argue that, at least in Brockington, this court has drawn a line that would suggest that upholding this pat frisk is unconstitutional.
You said that was a 128 counsel?
Yes, and I'm sorry, again, it's not a 128.
Rule 23.
Yes, thank you. Yes, I'm sorry, Erin. I was going to say I found it when I was shepherdizing, and I'm so old that I actually remember shepherdizing in the books, but I did find this on Lexis when I shepherdized. So, and so I think, at least in the context of that unpublished case, then the standard certainly hasn't been met here. I would like to just point out that obviously this whole issue of boundaries and what are the boundaries is sort of being hotly contested, especially in the Sweeting-Bailey case, which I think at this SJC is now called Bailey-Sweeting. But I would argue, in some ways, I thought, geez, maybe my client's case is worse than that case because of the furtive movements. But as I thought about it, that's it, right? I mean, there were furtive movements. The police officers didn't say that they thought there was any weapon. They couldn't say that they thought there was drugs. They just saw hands going back and forth. They responded to it. My client did everything he was supposed to do. Once they found out no one could take the car, he was absolutely free to leave. He was simply a passenger in a car that had been stopped for an inspection sticker violation where the police officers happened to pop a warrant. And I know Justice Shin, you had joined in Justice Maldonado's dissent in that, and I completely agree with the dissent, and I don't know how the SJC is going to decide this. But in some sense, I do think my client's case is better, because the situation that was presented in Sweeting-Bailey or Bailey-Sweeting was a very volatile one. We know that the driver was upset and sort of, going crazy, and, that he had convictions. We know that the defendant himself had convictions. The police officers, right or wrong, also rested their decision on, excuse me, that the defendant and two other passengers in the car were, quote unquote, verified gang members. What we have here is my client's a 19-year-old kid. He's with another kid driving a car that's uninspected, happens to have a warrant, God knows for what. The police officers aren't responding to a volatile scene here. They're not responding to a call on a crime. They're essentially pulling a car over because of an inspection sticker violation, and the driver happens to have a warrant. And I would suggest in those circumstances, first of all, I don't believe that, after the officers dealt with the issue by having my client hold up his hands and having all the people in the car comply, that there was a reasonable, there was danger to their safety or a reasonable suspicion of danger to their safety. But as I said, you can comb through the record. In fact, I think the judge's findings themselves support. I mean, if I was going through the judge's findings and I was saying, well, what here in the findings support that my client had a weapon and was inclined to use it, especially the inclined to use it part, because that's necessary. And there is nothing in the record. And I would suggest if the Commonwealth can point me to something great, but Your Honor, I suggest that there is nothing in the record to support that.
Why would he retrieve a weapon from the pocket of the car while the police were coming if he wasn't at least considering using it?
Well, first of all, the police don't know whether it's a weapon or not. I mean, we know that they happen to.
I think that's a big if, but if that
right,
is,
we know that that's what the if was. Okay, but again, this is even assuming that. What evidence is there that he was inclined to use it? Because his buddy was getting arrested on probably some kind of minor warrant. This wasn't a hot case or a situation where he's in a gang and needs to protect his buddy. I mean, as far as he knows, he can't drive the car home. There's no reasonable suspicion that he's committing a crime, so he's free to go. And that's what the case law says, Your Honor, that you're not supposed to detain somebody just to keep digging and digging. Once they determine that he can't drive the car, and at that point, there's not only the two officers on him, he's outnumbered at that point, and the cases say when somebody's outnumbered, that's something to look at. But not only those two officers, there's marked units behind them. This is a situation where the police had complete control over the situation. The situation wasn't volatile, and there's simply no evidence that he was inclined to use a weapon. Frankly, I don't think there was even enough evidence that he had a weapon, but even presuming that there was reasonable suspicion for that, the second prong has not been met. I see my time is coming to an end, but if Your Honors have any questions, I'm happy to answer them.
Any more questions? Okay, seeing none, we'll turn to the Commonwealth.
Morning, Your Honors. May it please the court. Ryan Raw from the Middlesex District Attorney's Office, representing the Commonwealth. Your Honor, this case is governed by the case laws established in Torres-Pagan and cited approvingly in Torres-Pagan, and the motion judge properly denied the defendant's motion to suppress, where there was sufficient reasonable articulable facts that the defendant was armed and dangerous, thus justifying the pat frisk. I want to start by pointing out that counsel's standard that's articulated here of intending to use the weapon, that's not cited as a standard in any of the cases that are upheld in Torres-Pagan as a justifiable pat frisk. That's not a standard that's argued in protective sweeps of vehicles. And the reason for that is quite common sense, that as the case law points out, officers do not have to gamble with their safety when there's reasonable articulable suspicion that someone's concealing a weapon. And when those facts exist, it would be unreasonable for police to have to wait to see if he attempts to pull it out in those circumstances, which is why pat frisks are routinely upheld in these circumstances where there are furtive movements. And looking at the case law cited in Torres-Pagan, it is quite clear that a furtive gesture of this type, reaching back and forth more than one occasion from the area in front of the defendant back to his midsection, and then quickly putting his hands in his pocket. Those are the facts, the strongest facts to suggest that the officers had concerns about their safety. There are some additional factors that are of lesser weight, but those are the main factors. And Stampley, Commonwealth v. Stampley, 437 Mass 323, in a footnote points out that the furtive gesture alone in these circumstances where there is enough evidence to suggest that someone's concealing an item that could pose a risk of safety to the officers is likely sufficient on its own to justify a pat frisk in this scenario. We have more than that here, but Torres-Pagan did not change the landscape in that regards. It specifically said the opposite. In footnote 5, it noted that even though it was clarifying the standard, it said all of the prior cases that conflated the standard, including the case cited by the motion judge, they were still upholding it. And they weren't saying that there was anything wrong with those decisions, that the pat frisk was justified. So unlike Torres-Pagan, This is a case that's governed by clearly established case law. Commonwealth versus Vanderlyn, when someone reaches into the well of a car during an investigation can justify a belief that they are attempting to retrieve a weapon and justify a protective sweep. Commonwealth versus Prevost, and it bent forward to conceal or retrieve an item, and he was, the police were not obligated to gamble with their safety, and there was a justification there of pat frisk. And so I believe that the cases cited in Torres Pagan make this firmly established that the officers had a reasonable basis to believe their safety was at risk. The case most on point is Commonwealth v. Stampley. I spend a lot of time in my brief discussing this, but I think it's important to point out that, like in Stampley, the police didn't just immediately take the defendant out of the car and pat frisk him at the first sight of an issue. They proceeded throughout the stop without attempting to quickly rush to judgment about what they needed to do to protect their safety. At all times, they maintained their safety as they could. They first told the defendant to put his hands up on the car. As they proceeded through the stop, it became clear that the defendant was going to be arrested for operating with a suspended license. I think the record suggests that that's what the arrest was for. Neither of them had a license status. The defendant had to be removed from the car, and the car itself posed potential safety risks to the officers. As the motion judge found, it was a two-door car. Trying to get the defendant out of the two-door car in light of his furtive movements towards his midsection made it so that the police decided to have him escorted out of the car and then immediately pat frisked in the area where he was reaching, which I point to not to suggest that that justifies the pat frisk within itself, but that the point in the case law in Commonwealth versus Prevost and in Torres Pagan suggests this has to be a minimally intrusive pat frisk to deal with what the ongoing safety concern is. So I would just say that this was clearly an ongoing safety concern for the officers. It did not dissipate simply because defendant complied with the request to put his hands on in front of him and within the plain view of the officers. I think Stampley also points that the police aren't supposed to just rely and lull themselves into a sense of false security simply because someone initially cooperates. Defendant did pose an ongoing risk, and they did not unconstitutionally prolong the stop. They needed to be sure that they weren't facing safety as they continued their investigation. And at this point in the investigation, when they asked him to exit, they still had to tow the car. They still had to finish processing the arrest of the driver. And so the defendant posed a risk by just having him leave the vehicle without being pat frisked for that concealed weapon. And so in light of those circumstances, I think
they hadn't issued any of the seatbelt citations at that point. Is that correct?
That's correct. They also hadn't issued the seatbelt citations at that point. And that was one of the bases that the motion judge found in an appropriate basis that they could ask for the identification of both passengers, which they did. And so just to sum up on the pat frisk in particular issue, the case law is very clear on this point about furtive gestures. The motion judge found it was a furtive gesture. It was one that was sufficiently detailed and described by the officers, and they only observed it because they were using a flashlight to try to look into the vehicle at this time of night. The additional factors which have less weight, I would acknowledge than obviously this is the most important piece, was that it was in a high crime area. The driver hadn't initially stopped, and when the defendant actually got in the car, which was after the driver hadn't initially stopped and they were trying to reroute and get behind the vehicle again and effectuate a stop, after the defendant got in the car, the driver opened the door without being asked to. And again, the officers, like in Stampley, pointed out at the motion to suppress that these were things that raised some apprehension to them, but they were willing to acknowledge that those behaviors could have potentially innocuous explanations. So they were being reasonable and they were being cautious, but they were not, overreacting by immediately ordering everyone out of the car or something of that effect. So in sum, I think that the pat frisk was justified in these circumstances based on the established case law.
Can we consider the high crime area in the analysis?
You can, and I think the case law is very clear you can. In terms, I know some of the newer cases have pointed out that there's sort of a tier of relevance of these based on the amount of information provided. And I would acknowledge that the amount of information provided was perhaps vaguer than some of the cases that have allowed it to be utilized at a higher level of relevance. It didn't specify a particular gun or weapon. It was a recent string of violent offenses, including robberies in the area. And the car stayed in the area of this high crime area throughout the entirety of the interaction, from their attempt to stop it to, and then the eventual stop of it. So I would assert you can consider it. I obviously understand that the case law suggests that it be given less weight than perhaps obviously the most important thing, which is the furtive gesture. But obviously the motion judge considered it as a factor among all the other factors during the stop. If there are no further questions, I just want to sum up by saying additionally that the police acted reasonably at the beginning of the stop by ordering him to put his hands up and produce his identification. Obviously, the exit order seems to be agreed that it was valid in these circumstances, and it was not an arrest. It was not tantamount to an arrest, and probable cause wasn't needed for the pat frisk. If there's no other questions, I just yield the rest of my time.
Okay, seeing no further questions, thank you both. I'm getting some feedback here, but
And we are back live and on the record.
right. The next case on our list is Cologne versus Puri, number 20 P1221. Attorney Hurley.
Thank you. Good morning. I apologize. I'm losing my voice. Please let me know if I cannot be understood. In thinking of this case, I think an analogy explains Sylvia Colon, the plaintiff in this medical malpractice matter, her position. Imagine that a passenger in an airplane is injured due to a rough emergency landing, and that passenger sues the co-pilots. And the co-pilots had written an incident report, and they identified themselves as operating the plane. The plaintiff goes against just one of the identified co-pilots, but then finds out that it was the other one who was actually operating the plane at the relevant times. This, I think, is an analogy to what Ms. Colon is facing. I ask the court to keep in mind, one, Sylvia Colon's absence of personal fault in anything, and two, obviously this is a medical malpractice case, so the tribunal is a very important part of it, and I'd like to address that to start. Both of the parties, meaning Dr. Lozano and Ms. Colon, address and cite an important Supreme Judicial Court case, Cap versus Ballantyne, a 380 Mass at 186. There were multiple defendants. The trial court, as a result of the tribunal, found no meritorious basis, and the case was dismissed because of the absence of a bond being posted for any of the defendants. No bond was posted by the plaintiff as to any of the defendants. So the SJC reversed and said that the experts submitted in that complicated psychiatric case that apparently involved electric shock said that that was sufficient, except as to two of the defendants. The defendant hospital, because it basically was a glorified hotel, wasn't responsible for the medical doctor's decisions. And then one doctor who had opined that the treatment might not be efficacious was found to not have any duty to stop the other doctors. That case, the CAP case, specifically uses the phrases infer about damages and whatnot. Turning to Ms. Colin's case, the tribunal offer by her rests primarily on the reports of Dr. Cousin and Dr. J. Krasner. Both of those were written in well, actually, Dr. Krasner's in 2018, Dr. Cousin in 2019. Dr. Krasner establishes causation. At the bottom of his report, which appears volume 1 of the record appendix, page 142, in the summary, Dr. Krasner identifies that to a reasonable degree of medical certainty, the femoral neuropathy exhibited by Ms. Colin in 2015 and 2016 was proximately caused by her femoral catheterization in February of 2015. And then the harm she sustained, he identifies as related to that. So, but then Dr. Krasner refrains from identifying a deviation from the applicable standard of care. So if we turn then to record appendix volume 1 at page 198, we can see Dr. Daniel Cousin, who is a specialist in radiology. He identifies at the bottom of that page, 198, volume 1 of the record appendix, quote, right femoral nerve damage and associated neuropathy should not occur if the right femoral access procedure is performed properly, unquote. Those two experts established the necessary elements of the tribunal's requirements. The medical malpractice tribunal law essentially says that the plaintiff has to show a doctor-patient relationship.
Counsel, you seem to be arguing that the tribunal just got it wrong, and even with what was presented with the evidence you had, should have found that Dr. Lozano, that it could proceed against him. But where did you raise that in your brief?
Your Honor, I don't think that based on what was present, the tribunal, from what they were presented, necessarily got it wrong. The argument is—
I apologize. I misunderstood them. I'm sorry.
The error of misidentifying the actual operator that Dr. Lozano claims was egregious, unacceptable, and beyond the pale. The irony is that it was Dr. Lozano, who was the actual operator, and Dr. Waklu, who created the confusion in the first place in two key areas. One, the February 3rd, 2015 operative report, which is completed by the senior doctor, Dr. Waklu, identifies both of them as being an operator. And the definition of operator is clear, that it's somebody who, in this context, is handling the specific mechanism. Then, in replying to one of the paragraphs of the plaintiff's complaint, all three of the defendants basically admit the allegation that Doctors Waklu and Lozano were operators. So from the plaintiff's perspective, the plaintiff was happy to proceed with one of the operators because we knew that he was an operator, according to the admissions, the binding admission in the answer to the complaint, which has never been altered. What happened here is that It is true that in the 23160L letter, the lawyers for the defendants did identify Dr. Lozano as the operator. But that is a lawyer's letter written in 2017. Its importance is subsumed by the actual pleadings. This case was filed late 2017, and the defendants filed their answers in 2018. And each of the answers said admitted that both doctors, Walkloo and Lozano, were the operators. So all we're asking is to be heard on the merits. Right now,
I guess I'm having trouble, counsel, because Lozano admitted in his answer that he performed the procedure. I'm not seeing how your client wasn't on notice that he was at least one of the operators and should have been included in the offer of proof before the tribunal. Regardless of the Dr. Walkloo's later answer to the interrogatory, which says that, again, that Lozano performed the procedure and he supervised. I mean, weren't you on notice of that, both from the answer to the claim letter and the answer to the complaint?
yes, and the tribunal decided no positive plaintiff finding as to Dr. Puri, which we had no opposition to. So when Dr. Lozano was dismissed, the plaintiff was deprived effectively of deciding whether or not to post a bond, because it didn't matter where the pleadings were binding and said that Dr. Walkloo, who remains in the case, was an operator, then the plaintiff's negligence claim was sufficient. It's only because of the defendants, meaning Dr. Lozano's answer to the complaint and Dr. Walkloo, if they are both operators, then the plaintiff's case wouldn't have been negatively impacted. So it is easy to say, well, the experts could have done something different, but the error originated from both the medical record and the pleadings.
All right, but I don't know if it was you personally, but your client didn't ask for extra time to post the bond, right? I mean, that really potentially could have been available, but instead, the way I read the motion to vacate that was filed, the motion was asking the Superior Court judge to simply reverse the tribunal's decision. And I'm not sure how the Superior Court would even have had the authority to do that. I mean, is it accurate to say that there was never a request for extra time to post the bonds?
Yes, Your Honor. The actual tribunal was in January of 2020, and the decision was immediately thereafter. The interrogatories answered by Dr. Walkloo came in April of 2020, which was well beyond the period for a bond. Procedurally, Ms. Colin is asking this court for something that I don't think is substantively different than what the plaintiff in the CAP case, the 1980 SJC case, asked for, where the appeals court, or the SJC, said that the findings as to most of the defendants will be reversed and the case will proceed without the necessity of posting a bond.
Right, but I mean, if you don't post the bond and the case is dismissed as to one of the defendants, what we're reviewing on appeal, from what I understand, is the decision of the tribunal, right? But I heard you to say earlier that you're not saying that the tribunal got it wrong. You're asking for a different kind of relief. You're asking for us to just reinstate Dr. Lozano as a defendant, even if the tribunal had it right based on the offer of proof before it. Is that what you're asking?
Yes, Your Honor.
So what gives us the authority to do that?
Because the error was caused by the defendant doctors Lozano and Waklu in not only their underlying report, but in their pleadings, and where Massachusetts General Laws, Chapter 231, Section 87, makes the pleadings binding, where the defendant who's out, Dr. Lozano, said in part that he and Dr. Waklu were the operators, then Ms. Colin and the tribunal and the experts, because notice that the expert reports were written after the answers, we rely to our detriment. So it's just a matter of enforcing the pleadings where there has been no motion to change the pleadings. Ms. Colin's main error was believing the pleadings, the answer to the complaint of Drs. Lozano and Waklu.
Can I just interrupt for a moment, Attorney Hurley? The complaint if you look at the answer for Lozano, he admits he's an operator. The discrepancy later is no discrepancy for him, right? He's still an operator. And the difference is that Waklu was the supervising doctor while Lozano was the actual operator, correct?
Yes, except, Your Honor, that Dr. Lozano did make a mistake because he admitted the allegation that both he and Dr. Waklu were operators. So Dr. Lozano was correct as to himself, incorrect in his pleading as to the other doctor.
But then the medical tribunal, and I realize we're out of time, still based their decision on Dr. Lozano being an operator, correct?
No, Your Honor, I think that what happened is that they based it on what the plaintiff's experts' reports wrote. And those reports reflect the pleadings. The expert reports were written in 2018 and 2019 after the defendants filed their answers.
Is there a reason why you're accepting Dr. Waklu's interrogatory answer as true?
No, it may well be false, particularly where he identified in his interrogatory answers that he didn't recall the procedure. So it may well be false, but right now, only Dr. Waklu is an active defendant. So we go forward, we may try to impeach him, but he was present and he says under oath it wasn't him. So then he points to the empty chair, and then Ms. Colin doesn't have her day in court on the merits.
Okay, thank you, counsel. Attorney Campbell.
Good morning, Your Honors. May it please the court. Lindsay Campbell on behalf of the appellee, Dr. J. Diego Lozano. This appeal should be denied as there was no error in the lower court's application of the law, and the trial court judge did not abuse his discretion. That is to say that Dr. Lozano was properly dismissed for plaintiff's failure to comply with Chapter 231, Section 60B, and that separate and final judgment was procedurally proper thereafter. Turning to the dismissal of Dr. Lozano, the lower court appropriately applied the provisions of Section 60B, and that statute details the screening requirements for claims against healthcare providers. As Your Honors know, at the time of the medical malpractice tribunal, the plaintiff appellant was required to present sufficient evidence to support the allegation that Dr. Lozano did not conform to good medical practice. Part of this burden includes the submission of an expert opinion, given that the nature of the claim was outside the knowledge of a layman. As determined by the tribunal panel, plaintiff failed to meet her burden. There were two offers of proof submitted in this case. The initial offer of proof contained the affidavit of Dr. Krasner, and a supplemental offer of proof was later provided, and that included an additional affidavit of Dr. Cousin. The two expert affidavits were considered by the tribunal panel, and significant to the appeal here today, neither expert submitted an opinion as to Dr. Lozano. In fact, I don't believe he's actually even mentioned in any way in either affidavit.
It's certainly mentioned in the Dr. Krasner statement. It says that the angiography was assisted by Dr. J. Diego Lozano, a fellow.
I stand mistaken then, but I would note that Dr. Krasner does state that he's unable to formulate an opinion about the standard of care, given it's outside the scope of his practice.
Dr. Krasner says the two of them performed the operation, and Dr. Cousin says it was performed incorrectly. Why isn't that enough to show that it should go as to both doctors?
Your Honor, the requirements of Section 60B are very specific. The expert needs to state that there was a duty owed by each defendant and that that duty was breached, that there was damage caused by that breach.
Does the expert need to say that, or does the tribunal have to have enough information to determine those things?
The expert has to say it, Your Honor, because the standard of care is something that needs to be proffered by a medical expert. After the tribunal,
our review is similar to reviewing directed verdict, right?
Correct.
So let's say you had somebody testify that these two doctors performed the procedure, and then you had an expert testify that the procedure did not meet the standard of care the way it was performed. That's not enough to survive directed verdict.
Correct, Your Honor. I agree that that does not survive a directed verdict.
Why not?
Because the expert has to state explicitly and at trial that there was a deviation from the standard of care by each defendant.
Well, Dr. Cousin doesn't say deviation from standard of care at all in his report, does he?
I believe he says that Dr. Waklu fell below the standard of care. There's nothing within the expert letters that addresses the care that was provided by Dr. Lozano. And this is in stark contrast to the information that was available to the appellant at the time of the tribunal hearing. The appellant had the 60L letter, which was a response, which indicated that Dr. Lozano performed the procedure under the supervision and guidance of Dr. Waklu. And notably, Dr. Waklu is not denying his involvement in the procedure, but the roles of the attending and the fellow are different. And given that there were expert opinions submitted here, clearly the medical experts can delineate and have knowledge about the different roles of an attending versus a fellow, and could have proffered an opinion like that.
Why, or maybe the answer is yes, is Dr. Waklu bound at trial by his answer that he performed the procedure?
I'm sorry, can you just repeat that?
Is Dr. Waklu bound at trial by his answer, his admission that he performed the procedure?
Yeah, and Dr. Waklu is not trying to escape that answer. And really, I think we're getting away from what the appeal here has to deal with. And the appeal here has to deal with the dismissal of Dr. Lozano based upon plaintiff's failure to comply with the tribunal process. After the tribunal found in favor of Dr. Lozano, the plaintiff was required to post a bond. She did not do so, at which I don't know if that was a strategic decision or what. It sounds like from Attorney Hurley, it was a strategic decision to proceed only against the attending physician. There was no request to extend the time to post the bond. There was no request to reduce the amount of bond so that further discovery could be done concerning the various roles of each physician. And therefore, a motion to dismiss was submitted. The motion to dismiss was not opposed, and therefore it was filed with the court as same. Based thereon, it was procedurally appropriate and in accordance with the rules of civil procedure for the trial court to dismiss Dr. Lozano.
So let's say there is newly discovered evidence. I'm not saying there was, but let's just assume there was. And it couldn't have been discovered earlier with any reasonable diligence. What is the mechanism? What is the remedy available to the plaintiff at that point? Is there a mechanism to go back to the tribunal and make a new offer of proof?
I think, Your Honor, at that point in time, it might have to pen back to the pleadings. I'm not exactly sure on the answer for that, but I would be happy to brief it if it would.
No,
be.
that's all right. That's all right.
The case law cited by the appellant, I just want to touch on briefly, and I do have it in my brief, but it's distinguishable in that those cases were reversed because the substance of the expert opinions was deemed to be sufficient on appeal. Here, there is no opinion as to Dr. Lozano. There is no opinion as to his role and whether he deviated from the standard of care. To now submit that his involvement was somehow unknown or newly discovered evidence or created by some intentional confusion on the part of Dr. Lozano is inaccurate and unsupported by the record. He has been clear about his role in this procedure from the outset. The information available to the appellant at the time of the tribunal regarding Dr. Lozano's involvement is contained at Record Appendix 2, page 95, Record Appendix 1, page 61, and Record Appendix 1, page 116. Record Appendix 2, page 95 is the 60L response letter, which we've already discussed and clearly delineates that Dr. Lozano performed the procedure alongside Dr. Walkloo. Record Appendix 1, page 61 is Dr. Lozano's answer to the complaint, where he admits that he was involved in the procedure. Respectfully, Your Honors, that paragraph in the plaintiff's complaint was in some way non-specific or inartfully crafted and included both Dr. Lozano and Dr. Walkloo's names is of no fault of Dr. Lozano's. He admits that he was involved. And at that point in time, at the filing of plaintiff's complaint, she had enough information to parse out the roles of the attending and the fellow based upon the pre-suit response letter. Finally, even if we take aside those pieces of information, we have the procedure note, which was reviewed, presumably, by plaintiff's experts. The procedure note at Record Appendix 1, page 116, clearly delineates both Dr. Lozano and Dr. Walkloo as operators. And in fact, Dr. Lozano is the first operator listed. I would submit that this respectfully was an inexcusable procedural error or a strategic decision made by the appellant, which should not be reversed. That the appellant and or her expert did not submit sufficient evidence against Dr. Lozano is of no fault of his own. Again, he has been clear about his role in this subject procedure from the outset. Based on this, the lower court appropriately applied the tribunal laws and the rules of civil procedure and dismissed him. Even if there was some confusion, again, there were mechanisms in place for the plaintiff to still proceed against Dr. Lozano. She could have posted bond, required additional time to discover new evidence, given, again, whether there was any confusion, or she could have requested a reduced bond in order to proceed to discovery.
Counsel, in your experience as a medical malpractice attorney, is it possible to get extra time to post the bond?
Yes, Your Honor.
Even though it's a statutory time period, you've in your experience, judges have extended that time period?
I have seen it, Your Honor, and I have seen also extreme reductions in the amount of bonds as well that's ordered. It's typically $6,000, and the lowest I've seen it reduced to is $100. Turning to the entry of separate and final judgment, which I believe is part of this appeal, and I have to just be honest, it's a little bit unclear, but given that the dismissal of Dr. Lozano was appropriate, The entry of separate and final judgment was appropriate and proper according to Rule 54B. This case involved multiple parties, and it was proceeding only as to one. There was a final adjudication as to the claims of Dr. Lozano, and there was no just delay. There was no just reason for delay of an appeal until the case resolved against Dr. Walkloo. The determination regarding whether there's a just reason for delay is within the sound discretion of the trial court judge. And it's only reversed, as your honors know, for an abuse of discretion. I'd submit there was no abuse of discretion here by Judge Ritter. In fact, he even waited to enter separate and final judgment until he heard our arguments and heard plaintiff's motion to vacate the dismissal of Dr. Lozano. His ruling and decision is at record appendix 2, page 149. And in sum, Judge Ritter found that reinstatement was not supported by good cause or excusable neglect. He found that the record did not support that Dr. Lozano's involvement was newly discovered evidence. And finally, he found that reinstatement would undermine the tribunal's screening role and the requirements imposed after an adverse tribunal finding. There are reasons that we have, and there must be procedural limits here, your honors. We cannot have litigants and defendants alike carrying on and claiming procedural errors and issues indefinitely. There was a clear procedure that had to be followed here, as it was a medical malpractice. It fell under Chapter 231, Section 60B. Plaintiff failed to present sufficient evidence against Dr. Lozano, failed to comply with any of the requirements or mechanisms after an adverse finding, and therefore dismissal and entry of separate and final judgment was appropriate. I'm happy to answer any other questions. Otherwise, I would just sum up that there was no error on the part of the lower court's application of the law, and the trial court judge did not abuse his discretion in entering separate and final judgment, and therefore, the appellee, Dr. Lozano, requests that this appeal be denied and that the judgment of the Superior Court be affirmed.
Okay, thank you, counsel. Thank you both. The case is submitted. For those who are watching, the panel will take its mid-morning break right now, and we will return in approximately 10 minutes.
Thank you.
Valid, except our position is that it's invalid only because of the elimination of a buffer zone under the zoning amendment, which is the subject matter of this appeal. In other words, we're not arguing that they can't put a marijuana facility there. We're arguing that they cannot put a marijuana facility in the so-called waterfront district while waiving a buffer zone requirement only in the waterfront district and nowhere else in the city of Haverhill. Now, we first look, and the law is very clear, and everybody, I think, agrees as to what the law is. The law is essentially that a zoning amendment is valid unless it's unreasonable or arbitrary, and unless it's contrary to the purpose of the ordinance and contrary to the health, safety, and welfare of the public. Everybody agrees on that. Now, let's get right to the heart of the issue. The zoning amendment that's the subject matter of this case is for recreational marijuana. And contrary to what the city did for medicinal marijuana, which has a mandatory buffer zone, when it came to recreational marijuana, they imposed a buffer zone requirement for the entire city except for this particular waterfront district. Now, why do you have a buffer zone is the first question. The answer is very, very clear. A buffer zone is designed to protect from adverse effects of whatever it is that you're trying to protect. And it's obviously for the benefit of the health, safety, and welfare of the public. Now, what they did in this particular case is they eliminated, obviously, it from the waterfront district. And Judge Foster used two reasons why they were able to, or what as a basis for removing only the waterfront district from the buffer zone requirement. Now, the intent of the ordinances is crystal clear. It's designed to protect the public from adverse effects of marijuana, and in particular, children where they gather or congregate for playgrounds, parks, et cetera, churches, or whatever you have. Judge Foster said the following.
That's one of the four purposes, right?
That's correct, Judge.
There's three other purposes.
The purpose was obviously to protect the public and in particular children from adverse effects. This facility is located right across the street from the so-called Columbus Park with less than 100 feet. And in the rear of the building is another waterfront park, which has bocce courts, picnic tables, etc., and I guess a big gazebo. The Columbus Park only has benches. So Judge Foster reasoned that it was a smaller park. Well, first of all, the ordinance does not say small parks. It says parks are municipal parks. Now, the good thing that happened, at least from our perspective, is that after Judge Foster rendered his decision and after the appeal was taken, the Supreme Judicial Court decided two cases. One I've cited in my brief. They were cited both on December 10th, 2020. The first case is Commonwealth versus Ramos Cabrera, and that's 486 Mass 364. The second case decided on the second day is Commonwealth versus Roger 486 Mass 358. And that was interpreting the criminal statute, which is Mass General Laws 94C, Section 32J. That's the statute that makes it a crime to sell, distribute, or anything like that, or use controlled substances near public parks and playgrounds, etc., amongst other things.
Well, counsel, can you walk me through how selling marijuana from a licensed marijuana establishment violates 32J?
Because it's right near 100 feet. It's within 100 feet of the statute of selling.
Don't you also need a person to violate Section 32D and to do so while in the commission of an offense, engaged in a course of conduct where you direct another person or using minors?
Right. Well, distribution of marijuana is still illegal in Massachusetts, and that's obviously a violation of the controlled substance statute.
I mean, you do realize it's not illegal to sell marijuana as long as you're part of a licensed marijuana establishment.
They could sell it. The problem is to whom they sell it. You walk across the street, Judge, and there's always the fear of somebody taking marijuana products and selling it to a kid or whoever is sitting or residing in the park. And that's what it is. It's designed to protect people in the public from being close to a marijuana facility, obviously using marijuana. Now, the SJC in that case decided, I don't know if Your Honor is familiar with it, but the SJC defined what a public park is in both cases. And the exact language was, quote, a public park, and in this case, in our case, it's a municipal park, but it's the same. It says, is a tract of land that is set apart or dedicated for public enjoyment or recreational use, number one, and number two, owned or maintained by a government entity. So clearly, when he came up with this situation of this argument that it's a smaller park, number one, it's not even based upon the wording in the statute, because clearly the city knew or should have known when they enacted these ordinances, because these are long existing parks that have been there for ages, as to what a park meant.
I don't think anyone's disputing that a smaller park is a park or a municipal park is a park. you're presenting it as a textual argument, but that seems to me to be besides the point. That the question is whether it was reasonable for the city to treat these parks differently because they don't have amenities that would attract children, and it's in a district that
Well, I'm sorry.
has many commercial establishments, and it only has to be fairly debatable. So
Let's think about that, Judge, just for a minute. What the judge was really saying is that even though the purpose of the zone that it's in was primarily residential, but it said it had a lot of commercial establishments. Ask yourself, Judge, do kids congregate downtown? My kids, when they were a lot younger, absolutely congregated downtown. And what's to say that kids who come from other districts that may not necessarily live there come downtown and they're not entitled to protection from the adverse use of marijuana? Boy, I think the big public policy behind what happened here is, this is, because we've done a lot of this stuff, this is the first instance that I'm aware of where a city or town attempted to eliminate a buffer zone for a particular or for any marijuana establishment. In this particular case, you can't do it for
There's no
medicinal.
park buffer zone in Brookline at all.
I'm sorry?
There's no park buffer zone in Brookline at all.
I don't, well, near a marijuana facility, I think you may be right, I'm not sure about that.
There isn't.
Oh, well, I'll take your word for it. But anyway, getting back to my argument is the fact in the public matter is, do we want these marijuana facilities near these playgrounds, parks, where the large, small, that frankly, kids in a smaller park are entitled to the same protection that kids in a larger park are, because that's nonsense. I mean, there's nothing in either any of the statute.
Why isn't that judgment one that's entrusted to the democratically elected city council?
Because they should have said that, Judge, in the ordinance. They knew, because it's obviously a municipal park, they knew that this was a municipal park in the waterfront district. They didn't say only small parks. They said all municipal parks or municipal parks, period. And how are we to infer, and how is Judge Foster to infer that it only meant small parks? I think it's the opposite, the complete opposite. And frankly, the establishment of a buffer zone is obviously for the public health, safety, and welfare. You do that to protect somebody from something. And what's going to happen here, Judge, is if this case, and this is the first of its kind, if this case is affirmed, that will entitle cities and towns to come up with excuses for eliminating buffer zones near parks because they all have them. And as a matter of fact, the medicinal one here, Judge, if you look, if this were medicinal.
Why can't cities decide they don't want park, like Brookline has, park buffer zones at all? Why can't they decide that?
Because first of all, as we saw from the ordinance here, they clearly knew and stated that the intent was to prevent adverse uses in adjacent areas. That's number one. Number two, they've got to have a rational basis for it that's related to the public health, the public safety, and the public welfare. They can't do it just for money, because what's going to happen here is if you affirm this case, is obviously the money is, comes from the host agreement. And by the way, if you read this week's Lawyers Weekly, you'll see what's already happening in the city of Haverhill. They've already have substantial adverse effects. And there's a major lawsuit apparently going on right now, including excessive drug use. And that it substantiates exactly why you have the ordinance and why it specifically says we're trying to cut down on the adverse uses of marijuana, and in particular, certain areas, parks, churches, and all that. In fact, if you follow Judge Foster's reading, does it also apply to a small church if there's one near it? And does it apply to a small school, or what? The intent is clear. Nobody ever argued what the intent was. The question is, did they have a right to do it? And then, do kids coming from other areas of the city of Haverhill have no protection when they come downtown? Whereas in every other place, you know, as a matter of fact, one other thing, Judge, if Judge Foster is right that because there's more commercial downtown than residential, but what it follows that in the other areas which are more residential, that's fine. But when it's commercial, but why? I mean, it makes no sense. Kids use commercial.
Why doesn't it make sense to allow a commercial establishment in a district that's already has a lot of commercial establishments?
I wouldn't argue that, Judge, except for the fact that I would say they have a much better argument if they didn't eliminate the buffer zone and made it uniform. You see, the whole purpose of spot zoning is to avoid this situation that happened here, where one particular person gets the extreme benefit of this. So the answer to your question, Judge, is very simple. They likely, although quite frankly, when the ordinance way back in 2006 that set up this zone, this LMEOZ zone was enacted. That was in 2006. Marijuana was the furthest thing away from anybody's thought. But marijuana is different, Judge, because for marijuana, number one, we obviously know it's highly regulated, to say the least. And number two, you need a special permit. This is not like a barber shop or a grocery store where, you know, these are a matter of right. They are not a matter of right. Why? Because marijuana is different. And we all know that.
Why isn't it rational to think the special permit process will allow you to minimize the impact through conditions that you impose, as opposed to, say, a restaurant where, like your clients can do as of right?
Well, they can, and that's what they did in this particular case. They indicated that you need a buffer zone everywhere else, and the reason why you need the buffer zone. But they said excluded from the without any reason, excluded from the waterfront district. And you know, then comes, and that's what the issue in this case is. Was that a rational, valid decision that promotes the health, safety, and welfare? It's the opposite. It doesn't. Because the buffer zone is intended specifically to promote the health, safety, and welfare of the public, and especially children. And, you know, it's illogical and inconsistent. And if your honors do affirm this, you're encouraging the cities and towns to come up with, as they did in this particular case, some excuse to eliminate it so they can get money. Because these things are very profitable for the cities and towns, although Haverhill is now.
Attorney Nathanson, your time has expired. Let me just check with the panel, see if there are any other questions.
Thank you, Your Honors. I appreciate it.
Attorney Bobrowski.
Thank you, Your Honor. Good morning. The city of Haverhill has it within its public purposes, its sovereign authority, to regulate the downtown in a different manner than it regulates medical marijuana in a more suburban location. So where Attorney Nathanson points to the medical overlay district as having a buffer, it doesn't matter. It's not relevant to the downtown area of Haverhill, which is completely different in character. The location of the marijuana facility that we're debating here today is in the hub of the downtown. I've been working in Haverhill for 20 years. And I can tell you that the city has made a tremendous comeback. Using smart growth money from the Commonwealth, they have restored the downtown almost completely. New train station, new parking garage, vibrant city life after dark, restaurants, shops. It's a changed place in the 20 years I've been there. So the decision to make this retail area only a licensed marijuana district fit within that character was carefully taken by the city council. The waterfront district, which was adopted maybe a decade ago, is directly designed to promote vitality in the downtown area. Bars, restaurants, all allowed as of right, along with retail. So in making this district, the city council was mindful that the more people come to downtown, the better the downtown recovers from the blight that it suffered 20 to 40 years ago. And that's essentially the flaw in Attorney Nathanson's argument. He says the city has no power to decide that a buffer zone is inappropriate in this area, where the city has the autonomy to make that decision on its own. This is a home rule state. If the city decides the best way to promote the recovery of the downtown and manage the business of marijuana sales, and I'm looking at the purposes of the LMEOZ, do so in appropriate places and under specific conditions, it has it within its authority to do that by its own design. So first and foremost, as Judge Foster pointed out, the city has to make a case that it is promoting a legitimate government purpose. The burden will shift after that to the challenger, and that's a heavy burden. Judge Foster correctly ruled that the city had a legitimate purpose in mind: economic vitality, all stated in the LMEOZ purpose clause, to regulate marijuana retail in appropriate places and under specific conditions, to address siting, design, placement, access, security, safety, and monitoring, and to provide clear guidance to applicants for the permits. The most important one for our purposes here is to regulate in appropriate places under specific conditions. That's exactly what the retail-only district downtown is designed to do. And it has to be read hand in hand with the waterfront district. One of Attorney Nathanson's arguments in his brief is that there was no planning in effect in the adoption of the marijuana subzone. Of course there was. It was designed exactly to fit and be tailored into the waterfront subzone A. With regard to the burden shifting now to the other side to show that there was no legitimate governmental purpose behind the regulation, or that it was somehow invalid for another reason, Attorney Nathanson has a long row to hoe. He makes a number of different arguments. First, he points out that the medical marijuana district is governed differently. I pointed out that it's in an entirely different character area than the downtown of Haverhill. And these matters are covered in my brief beginning in argument 2. So the absence of a subzone does not treat different people differently. This is a uniformity argument that was raised under Chapter 48, Section 4 by Attorney Nathanson. There is no planning requirement, as he's asserted in his brief. It's a long-standing principle in Massachusetts zoning law that the most that's required of a municipality in planning before zoning is that it give conscious thought to the end result. But the court specifically rejected. We are not a comprehensive plan state, unlike about 35 others in the nation. So the obligation to plan would be nice, but it's not an imposition that municipalities have to pay legal respect to. And in any case, it has no relevance here because the city engaged in a comprehensive planning effort when it did the waterfront district only a decade earlier. And Judge Foster gave credit to that comprehensive planning in his decision. I believe it was on about page 94 in record volume 4 of the appendix. The attack also includes, by Mr. Nathanson, a challenge to the notice requirement. And I think the notice requirement, as Judge Foster ruled, fits exactly with the absence of a buffer requirement. In lieu of a buffer requirement in this dense, vibrant neighborhood, the hub of the city, and a broader notice requirement is provided. Instead of abutters or abutters of abutters within 300 feet, everyone gets notice within 300 feet. And the expectation is that if they have an issue or something they'd like to see addressed by the city council, they'll turn out for the city council public hearing. So there is, in effect, adequate safeguards for the proper management of the business. And Judge Foster accordingly ruled. And then lastly, it's not spot zoning. There is a charge by Attorney Nathanson in his brief that the end result here, with Haverhill STEM being the only shop open, is somehow a determination to treat this property differently. In fact, the entire district is one. This is just the spot that was selected for commercial operations. It could have been anywhere, and that provision can be waived, as Judge Foster pointed out. I want to leave some time for Attorney McMillan. Sorry, I went over.
Are you still?
I believe this is still your remaining time. Attorney
I'm
Barrett.
sorry, I didn't know that.
If you have anything else to say, you're of course welcome to.
No, I'll rely on my brief. I think Judge Foster's decision was eminently wise, and I agree with all of the points that he made. I've reiterated them in my brief for the most part and provided a little augmentation, but for the most part, I think it's a well-written, thoroughly correct trial court decision from the land court.
Okay, thank you.
Thank you.
Attorney McMillan.
Thank you, Your Honor. Good afternoon. May it please the court, Thomas McMillan appearing on behalf of the private defendants, Haverhill STEM, Pinot Projects, and the Westland Group. While we were not the focus of the subject of the motion for summary judgment in the land court, we did end up joining in with the city defendant, both on its opposition as well as its cross motion. And we've also obviously joined in with them on their brief and incorporated it in our limited brief to the extent that we agree with them, both on the zoning issues as well as the other arguments that have been raised in it. So what I'd like to focus during my time is predominantly on two things. One is the issue of spot zoning, and the other is the additional arguments that were included by the plaintiffs in their brief. Turning first to the spot zoning issue, the plaintiffs have harped on that for quite some time, alleging that Haverhill STEM, and in particular Caroline Pinot, who is a managing member of STEM, somehow influenced the city of Haverhill to drop the buffer zone with respect to the waterfront district. And although they do make a number of different sites in their brief, I think if one goes and actually looks to the information that they've cited, it doesn't support their contention that Caroline Pinot had any type of influence with respect to the dropping of the buffer zone. And in fact, it's quite the contrary. The statement of facts is objected on that particular issue by the city defendant. And most of the references that the plaintiffs make goes to either their statement of fact without the notation of the dispute that it was not an accurate statement, or more importantly to their complaint, which of course is not an established fact.
What's weird about spot zoning in this context is, of course, you have to negotiate a host community agreement with the city council anyhow. So the city council, at least on paper, has all the cards either way. What limitations do you think there are on a municipality's ability to refuse to engage, to enter into a host community agreement?
Well, that's actually a very good question, Your Honor. I think that is an area of the law which now is starting to develop, because I don't think that there's a lot of case law with respect to the host community agreements. And I know that there's not a lot of definition. There might, in fact, even be a little bit of a tug and war between the administrative branches, the Cannabis Control Commission, as to how much authority they have with respect to these host community agreements. And while the city does hold the upper hand, I suppose, in saying that if you want to be able to do business in the city, then you're going to have to agree to the terms that are contained in the host community agreement. It's essentially, from our perspective, an adhesion contract, because the operators who are seeking to get their license, they need to get a HCA in order to get approved by the Cannabis Control Commission. And so they have to eventually compromise and basically go along with whatever the city wants to do in terms of imposing upon them the conditions, both with the amount and the duration. Now, there are some obviously limitations as to both of those factors. The city cannot charge more than 3% of the gross sales, and the duration cannot be more than 5 years. But a lot of communities are going ahead and doing that. They're doing it at the highest amount. The issue becomes it's not just a free giveaway with respect to the impact fees. The taxes, that's one issue. The impact fees, they have to be justified by the city. And that's an area, as I've indicated, I think is starting to be developed now as a result of case law. But with respect to the spot zoning, there's no evidence in this particular case that in fact happened. In fact, to the contrary, the judge's order indicated on a number of different levels that it didn't happen. And even ironically, the judge notes in his decision that even if that was the case, it didn't matter, because that's not the factor that the court takes a look at to see whether it was or was not approved correctly. If I can read from the okay, so the judge's order on page 20 of the order says whether the city council enacted these preventions with the intention of benefiting STEM's retail marijuana establishment is irrelevant. What matters is whether the LMERO can reasonably be said to be in furtherance of purposes and of chapter 40A and the police power. And then he goes on to explain how that was done in this particular case. I agree with Attorney Babowski. I think Judge Foster wrote a very comprehensive and detailed order, and from our perspective, we would respectfully request that it be upheld.
Thank you. Any other questions from the panel? All right.
Good afternoon, Your Honor.
And we are back live and on the record.
Okay, the last case on our list today is Deutsche Bank National Trust Company versus John Pepe and others, number 20P1275. Attorney Terrian.
Good afternoon, Your Honors. May it please the court. My name is Greg Terrian and I represent the Pepes. This is an appeal from a grant of a summary judgment in favor of the former mortgagee Deutsche Bank National Trust Company as trustee for a certain trust in connection with a case involving post-foreclosure eviction. Sometime in 2017, and I'm going to refer to the former mortgagee simply as Deutsche and my clients Pepe collectively. So sometime in 2017, Deutsche chose to exercise the power of sale found in the subject mortgage, and it scheduled a foreclosure auction to occur on August 10th, 2017 at approximately 3 p.m. The heart of the matter here, Your Honors, is that on August 1st, 2017, the counsel for the Pepes sent a letter of representation to the attorney who was representing Deutsche in putting foreclosure together. That was Puri and Associates. And essentially the letter urged the firm to cancel the foreclosure auction, and it advised that the proceedings had a host of issues. Now, the auction was held as intended on August 1st, 2017 at 3 p.m.
Auction was August 10th.
And following, I apologize.
August 10th, right? The auction was 9 days after the letter, right?
Yes, that's correct, Your Honor. 9 days. Following the foreclosure auction, Deutsche, who was the highest bidder, who bought the property, filed a summary process, and ultimately the summary judgment record contained the certified copy of the foreclosure deed with an affidavit in compliance with 244-15, thus satisfying the prima facie case for possession following post-foreclosure eviction. Now, also what the summary judgment record contained is certain green cards, which typically are issued by the post office as a receipt for certified mailing in the return cards. Interestingly enough, none of them contained any dates whatsoever. None of them contained.
Counsel, your friend relies exclusively on the actual notice. So I think it might be useful to explain to us why actual notice isn't sufficient.
So, Your Honor, the court relies on the Hull case. And in the Hull case, essentially, it summarizes as follows. It says that the summary judgment was proper for the reason, comma, if no other, comma, that the materials before the judge show that the plaintiff had actual notice of the foreclosure sale. Now, in that particular case, Your Honors, in Hull, the former mortgagor actually reaches out to the former mortgagee, and it basically provides a verbiage, the language for a proffered sale ad. and essentially that constituted the actual notice. Now, if you also look at the case, if you look at the decision, Your Honor, it is apparent that Hull case summary judgment record also contained evidence of returned notice as undelivered.
Right, but the holding is summary judgment was proper for the reason, if no other, as you just quoted, that the plaintiff had actual notice of the sale, right? So it seems to me that the reference to the returned mailings is dicta. It's not necessary to the holding.
Well, I agree. I agree with that, Your Honor. Now, what I would say, though, however, this is a 1992 case, and since then we had quite a few cases, which basically, quite frankly, followed, you know, practices by the banking industry, which really needed a lot of correction. And I think what we have here, we have a result where an attorney reviews of the record of the client and finds a fatal flaw. And the fatal flaw, among others, is that the bank failed to comply with the statutory requirement found in 244-14, specifically non-compliance with mailing of the registered mail notice to the mortgagor to let them know that there's going to be a foreclosure auction. So now, if the attorney reaches out to the mortgagee and says, time out, we have a problem with this, with the compliance with the terms of the power of sale, apparently that letter can be used as a cure to non-compliance. So we have
no. The basis of the summary judgment was that the letter is proof of actual notice.
Well, again,
do you contest that letter is sufficient proof of actual notice?
Well, I agree that I was aware that there had been a foreclosure auction scheduled for August 10th, 2017 at 3 p.m. because within the letter itself, I certainly
and do you agree that that is proof of actual notice to your clients?
What I would say, Your Honor, is no, I would not agree with that.
Why not?
So in the order, the judge definitely does say that, you know, my knowledge should be attributed to my clients, the PEPIs. What I would say, Your Honor, is this isn't a direct contradiction to the statutory scheme, which
no, I understand that, but as a factual matter, actually, I think the better question is, as a factual matter, did you contest at the summary judgment stage whether your clients had actual notice based on this letter? Is that a disputed fact? Okay,
no,
so it's not a disputed fact. So we accept that your clients had actual notice. So if we accept that, then why doesn't Hull apply? That's what I'm not understanding.
Well, Your Honor, again, what I would say is I think it's going to create havoc in.
So you want us to overrule Hull?
I think, Your Honor, otherwise we're having a problem otherwise, yes.
I'm asking a very straightforward question. Are you distinguishing Hull or are you asking us to overrule Hull?
I am doing both, Your Honor.
So how do you distinguish Hull? That's what I'm not understanding.
Okay, I distinguish Hull in respect that in that case, there actually was an actual real proof that the mailing did in fact occur in compliance with the statute. In this case, we have absolutely no proof other than the affidavit of compliance.
Attorney Tarian, if I may, if we were to accept your argument and just follow with me for a moment.
Yes, Your Honor.
That summary judgment shouldn't have been granted because the bank didn't provide the adequate certified mail proof, correct? Regardless of whether you knew it as an attorney or not, right? So let me forward you this hypothetical.
Yes, Your Honor.
The bank happens to be the next door neighbor of the Pepes, and the bank president likes the Pepes very much, sees them every day outside mowing their lawn, and he walks over there. He's got a notice in hand, it's videotaped. He goes over to the Pepes and says, I'm really sorry. Here's all the information, but on August 10th, we have to foreclose upon your property, but I wanted to tell you in person because I've been a neighbor of yours for years. You're telling me under your position, that wouldn't be good enough.
That's correct, Your Honor. That is what I'm saying.
But what would be good enough is the mere fact of a mortgagor sending out certified mail, regardless of whether it was received or not. So
Correct.
Actual notice is not enough, is your argument.
My argument is that he who invokes the statutory power of sale must comply with the terms thereof strictly. And the strict compliance requires compliance with the statute.
So you're asking us to overrule Hull?
Yes, Your Honor.
And how does that make sense, what you're asking us to hold? Because, so what I understand the purpose of the mailing requirement to be is, as Judge Walsh pointed out, actual notice is not required, right? It's just the mailing. And this is a way to maximize the chances of the mailing getting to the person, right? So, but because they don't have to prove actual receipt of it. But if you have a case such as the hypothetical that Justice Walsh posed, where you have conclusive proof that they actually received it and they knew about it, I don't understand how it makes sense to construe the statute the way you're asking us to.
Because, Your Honor, the case law is clear again, where non-judicial jurisdiction with respect to foreclosures, there is no judicial oversight. And
about strict, I mean, but it begs the question, what is meant by strict compliance? Because these requirements are in there as safeguards. But if you have a situation where you actually don't need the safeguard because there's conclusive proof of actual notice, then why would we construe the statute that way?
because in reading of the statute is found under Mass General Laws 244-14, allows for no other interpretation.
Attorney Tarian, doesn't it set the minimum standards for the mortgagor to have to follow? In other words, you want us to interpret that if they do more and do a better job, that it's insufficient.
All I'm just saying, Your Honor, is all they need to do is just strictly comply with its terms. And what I think Hull does is creates a situation where a mortgagee has an opportunity to skate on thin ice without compliance, and then essentially get away with not strictly complying with the terms of the power of sale. I think that's exactly what we have.
What if the bank hand delivered 20 days before the foreclosure and got a signed receipt from the homeowners? Would that be enough?
I don't know, Your Honor. I don't know the answer to that question. I guess I am going to, my position is, Your Honor, let's look at what the case law says and what the statutes say. And I know the case law says if you're going to comply with the terms of the sale found in the mortgage, comply strictly, or you could seek judicial oversight. I think, Your Honor,
you're familiar with the principle of statutory construction that we don't construe statutes to produce absurd results.
Yes.
Right? So I still haven't heard an answer from you about why your construction of the statute makes sense. Because if we construe it the way you want us to, then even if the notice was hand delivered and there was proof of receipt, that wouldn't be enough in your view. That's how you're asking us to construe the statute.
Well, Your Honor, I understand, but let me draw a little hypothetical. You have you have two exact situations. You have Pepe's and then you have Smith's. Their foreclosure auctions are scheduled on the same day. Pepe's say, you know, and by the way, both of them do not receive certified mailings. None of them do. So Pepe's, they hire an attorney. An attorney says, your foreclosure is going to be set aside because they did not comply with the statute. Because through my diligent analysis, I found out there was a foreclosure auction scheduled. Now, Pepe's go to Smith's and say, guess what? My attorney said we're going to be all set. We're not, our foreclosures are going to be set aside because they're incorrect. Both cases go in front of the judge. Pepe's summary judgment contains a letter, like a Tarian letter, and Smith's summary record does not contain the Tarian letter. According to the analysis of the judge, Pepe's foreclosure is set aside. Smith's foreclosure Pepe's foreclosure is okay. Summary judgment is granted. Smith's foreclosure is set aside.
Why is that bad? Pepe has actual notice and Smith doesn't.
Well, Smith does have actual notice because Pepe's home.
Smith was just told he's going to be all set, not that he was told of the auction.
I understand, Your Honor. What I mean to say is that the information of foreclosure is communicated to Smiths, and they are aware.
Wouldn't the Smiths lose also under the opinion we have because they have actual notice? It might be a little harder to prove, but you could give them an interrogatory asking them, when did you first learn about this? And get an answer, and that would prove it pretty easily. Or you could have the Pepes testify.
I guess that'd be plausible, Your Honor. It's certainly plausible, but speculative. But nevertheless, under this analysis, we have a dangerous situation where the exact same set of facts, where we could have completely different outcomes.
Okay, thank you, counsel. Any other questions from the panel? All right, Attorney Sprague.
Good afternoon, Your Honors, and may it please the court. Stephanie Sprague here for Deutsche Bank as trustee. And Your Honors, I would submit that the lower court was correct in granting summary judgment to my client in the summary process for possession of the property following a valid foreclosure. There's no dispute here that my client did make out its prima facie case with the foreclosure deed and the affidavit of sale, establishing that it complied with the statutory power of sale. At that point, the burden does shift to the defendants to put some fact of the prima facie case in a genuine dispute. And that is what we do not have here. We do not have any material fact that's in a genuine dispute. I will point out at the onset that the lower court judge actually found that the burden, that the Pepes never satisfied the burden to shift the burden of proof back to the bank because only one mortgagor actually put in an affidavit regarding non-receipt. The other mortgagor didn't. So the lower court did.
Since that mortgagor said, I'm the one who's in charge of getting the mail, doesn't that, and no such letter, doesn't that establish that neither of them got it?
Your Honor, I would say no. The other mortgagor could have put in an affidavit saying, yes, he's in charge of getting the mail. I never get the mail. I never touch it.
Well, it certainly could have, and you could have gotten his priest to file an affidavit saying he's an honest guy. I mean, but that's not what we do. Is there enough evidence to find this? Isn't there enough evidence to find, at least for summary judgment purposes, that neither of them got notice? Mailed notice, not actual notice.
Right, Your Honor. That if the court wanted to say that affidavit was sufficient, I can concede that point. However, again, it's not a material fact for this summary judgment and for this case because, and I believe Attorney Tarian does concede this, actual receipt of the notice is immaterial. So my client did put in some evidence regarding the notice of sale that was sent, dated July 20th, 2017. We put in the green cards. No, they were not stamped by the post office. The amount of the postage was on there. But all of that, again, is essentially irrelevant in this case because of the Hull case. Now in Hull, it did go up on appeal twice. The first time they remanded it saying, we want to develop the record more sufficiently regarding whether the bank sent the notices. When it went back on remand, there was more evidence regarding what the bank put in, for the notices, but also we had this evidence that the mortgagor, who was an attorney himself, sent this letter acknowledging the date and making some suggested changes to certain language, but he did acknowledge the date of the foreclosure, so he had actual notice. Now on appeal, the appeals court focused almost wholly on that, on the actual notice. They did not focus on, well, the bank, sent out the letters and it wasn't returned to them, and they have the green card, and the green card, the certified mail wasn't returned. That was not the appeals court's focus in Hull 2. It was on actual notice.
Well, counsel, when Hull 2 was decided, was before anyone thought you had to strictly comply with Section 14. But now we've got several SJC opinions that tell us you do have to strictly comply. How do we reconcile Hull 2 with those decisions? Hull 2 does not seem requiring strict compliance with 14, whatever else its merits.
Yes, Your Honor, and I understand since 1992, there's been a slew of cases, very significantly changing this area of law from Bailey to Ibanez in 2011, Eaton in 2012, Pinty in 2015. But what I would say, even after all of those cases were decided and made newly clear since 2011, the level of strict compliance that a bank will be held to, there have been cases since then that have still followed Hull 2. That included in 2016, and I cited that in my brief, Kia versus Carpenter. And in Kia versus Carpenter, that was 2016. So that was after all of those cases have come out. And by 2016, it's very apparent that strict compliance is needed. And in there, the court said that if there's actual notice, failure to comply with the registered or certified requirements is not a fatal deviation from the statutory procedure. So unlike what—
it's an unpublished decision and it doesn't discuss Ibanez or James B. Nutt or any of the cases with that. So, we're not bound with it. So I think you need to convince us that it's right, not just that it happened.
Absolutely, Your Honor. It's not a published decision. And the other cases I cite are also not published decisions. There's one from the appellate division that was in 2019, and again said that it's not fatal because the purpose of the statute, as Hull 2 said, is to give actual notice. It's a boot and suspenders kind of statute. We're going to publish it. We're going to send it by certified mail. We're going to send it by first class mail to everybody who has any record association with this mortgage, with the property. We're going to send it to everyone because the purpose is to make sure the mortgagors know this is going to happen. That purpose was accomplished.
Even if the purpose is established by actual notice, why does 9 days of actual notice enough when the statute definitely wants 14 days of actual notice for whatever planning purposes the homeowner would need?
Well, the statute says that it must be sent 14 days before. I would submit if you send notice 14 days before, you're not guaranteed, there's no way that notice could get to them 14 days before. It would certainly take several days for the mail to get to them, but one can assume that the mail will get to them within that 14-day period. So there's no case law that I'm aware of and nothing in the statute that says it has to be received by 14 days before. And as Hull 1 says, as Attorney Tarian concedes, there's no requirement for receipt of it whatsoever. It just has to be sent 14 days before. So we can even plausibly assume that it was sent 14 days before because at least 9 days before they knew about it. And that's all speculation. That's certainly not before this court. But what we do have is actual notice. And I don't see any way to distinguish this from Hull 2. I think the only plausible argument is to entirely overturn Hull 2. And as far as my research shows, there hasn't been any cases that have disagreed with that, even with strict compliance being necessary for several years now. I'm not aware of any case that has distinguished Hull 2, has overturned Hull 2, has suggested it should be overturned where there is actual notice. Proof of actual notice is unusual.
So strict compliance doesn't mean strict compliance. Can you articulate a standard for when we require strict compliance and not? Why does it, when does it make sense and when does it not?
You know, I would say strict compliance would make sense where the failure to strictly comply could actually have the unintended consequence that strict compliance intended. So in this case, the reason why you need strict compliance is so that the mortgagors know that there is a foreclosure coming. One of the reasons why they need to know a foreclosure is coming is because, like under Pinty, they have the right to file a lawsuit before the foreclosure, and many of them do, to stop the foreclosure. Certainly, if the Pepis understood a foreclosure was coming as of October 1st, and they had any reason to believe that it would be voided, and there were these unspecified issues that would void a foreclosure, they had the ability to file a TRO, to file a lawsuit. Mortgagors very often do. So that is, to strictly comply would be to make sure that you accomplish the purpose of the statute. And in this case, the purpose of the statute was complied with.
Is your position strict compliance to the minimal requirements of the statute? And when you do more than the minimal requirements, that it doesn't apply?
It's whether the purpose of the statute was accomplished. So I would say if there was conclusive proof that, you know, maybe in your hypothetical, if it's the neighbor who comes over and says, I'm sorry, but, you know, we have to foreclose on you. And then for some reason, the neighbor thought, well, you know what, now I don't even have to put it in the newspaper. I don't have to send it by mail. I don't have to do any of that. I can't even sign an affidavit of sale saying I've complied with 244, section 14, doing all that, because I didn't, but I gave them actual notice. In that case, I think there would be a much stronger argument to say that the statute was not complied with because they specifically did not do anything to comply with the statute, and we wouldn't be able to make out a prima facie case because we wouldn't be able to have an affidavit of sale saying I have complied with the statute. In this case, we have made our prima facie case. We do have an affidavit that said we did mail these out. They tried to make a dispute of that fact, dispute our affidavit with their affidavit. And what we're saying is the case law makes clear that that dispute does not bring up a genuine dispute in this case because they do have actual knowledge. And I would also point out the letter itself, my brother complains that, well, this would make it difficult for borrowers to get counsel because, you know, if we can't send a letter saying, hey, you didn't comply with the statutory power of sale, there's a problem, we didn't get notice, then that's an issue. But this letter didn't say that. This letter didn't say my clients didn't get notice or you didn't comply with the statutory power of sale. It didn't say anything about what could plausibly be wrong. It just said there's some issues and I think it's going to be voided. There was nothing specific in there about we didn't get notice. You know, you haven't complied with this, that, or the other thing. Nothing about that is actually in this letter. What I see is happening if mortgagors were allowed to have actual notice from however they got it, whether they saw it in the newspaper. I've seen cases where people say, well, my friend saw it in the newspaper and they texted it to me. And that's how I knew there was going to be foreclosure. They run to court. However they got notice, if they decide, well, you know what, I don't think they sent it to me by registered mail. I don't remember seeing that in the mail. So I'm just going to stick my head in the sand. I'm going to pretend it didn't happen. I think that's what's going to, you know, possibly be the outcome. And then we're going to have more issues down the line, even if they get an attorney and the attorney says, well, okay, if you know about this, let's do something about this beforehand. And they say, no, well, we prefer to stick our head in the sand. I think that would be not the wisest move on the part of the attorney if they have actual reasons to say that the foreclosure will plausibly be void if there's title issues, if there's any way that they did not comply with the statutory power of sale beforehand and instead choose to ignore those issues and allow the foreclosure to actually go through. I think that would be bigger problems for each side if that were to happen. So in the end, I think the evidence is clear in this case. There's no cases that say if there's actual notice, they knew it was going to happen, that the alleged failure to send certified mail alleged by one of the mortgagors would be sufficient to overturn an otherwise valid foreclosure in a summary process case. And if your honors don't have any more questions, I'll rest there.
Any other questions? Okay, thank you, counsel. Thank you to both of you. The case is submitted. That concludes our session for today. Have a